Kia ora koutou. My name's Louise Taylor. I'm the chair of the independent panel appointed by Central Otago District Council to hear and decide the application of Glenoir LP to subdivide and provide for future residential activity at 155 and 157 Dunstan Road. We will introduce ourselves, and then I'll have the staff introduce themselves. We'll do a quick health and safety. I'll do a little bit of an intro about how we'll run the day, and then I'll see if there's any procedural matters, and then we'll take appearances. Just to let you know, the hearing is being recorded, and we will have, I think, at least one witness coming in online later today. So.
My name is Wendy Baker. I'm a planning consultant based in Arrowtown.
Thank you.
Morena koutou. My name is Ros Day Cleven. I'm an independent commissioner based in Dunedin, and I have a background in resource management planning.
I'm Taryn Lyons. I'm the hearing administrator for CODC.
Thank you.
I'm Tanya Copeland. I'm the reporting officer for Central Otago District Council.
And then do a health and safety. Yes, no, we'll.
Yep. So in the event of a fire, obviously we have exits all labelled where to go out and to meet in the church. Just let me double check that. So sorry. Yeah, in the church grounds.
Morning.
Interesting start. Good morning. And bathrooms are just straight down and to the left.
Thank you. So just to let you know, we have read all the papers in advance. Thank you to the applicant for your evidence for the application. We have read that. Thank you to the submitters for your submissions. We have read all of those, so no one needs to read annual reporting. Thank you, team. Nobody needs to read any of that out. What we would like is for you to bring to our attention key matters that you think is important for us, so that we can make the best decision we can. If you've pre-circulated evidence in particular, so the applicant team, just a really high notes would be great. I don't know if you've prepared summaries.
Yeah.
You have, okay.
2 pages.
Perfect. Just read those, that's fine. And in particular, we're interested in addressing the matters where the witnesses differ in their opinions to the council staff, and also in terms of submitter matters. So those are things we'd really like to be focused on. If you haven't pre-circulated evidence, and I don't think we have received any from submitters, that's completely fine. But if you do have anything prepared in writing, it would be really handy if you can give that to Taryn at the end, so that we've got a copy of that. Through the hearing, we will ask lots of questions. If we don't ask you any questions, that's fine. It's probably because we understand the points you're making. We also will talk about the conditions of consent quite a lot. That doesn't mean we've made a decision. We haven't, about whether to grant or not, but this is our opportunity to understand that if we were to grant the application, what conditions would be appropriate to impose on the consent to ensure effects are mitigated and the activities are managed appropriately. So we will get into conditions quite a lot today. That doesn't mean we've got any preconceived view about whether to grant or not. We took a site visit yesterday, or site familiarisation yesterday. That was really helpful. We identified a number of the submitters' properties and obviously the site itself. We may or may not want to go back. We'll make a decision during the day, but certainly we've had a pretty good look around yesterday. In terms of how things roll, for those who are not, this isn't your usual place to be, totally understand that. Please feel welcome. We're really here to understand the issues and make the best decision we can. There will be no cross-examination. If you have a burning question you wanted to ask of another party, so the applicant team or a submitter or staff, you need to ask me when it's your time to speak, and I'll decide whether that is an appropriate question. But generally speaking, we won't have any questions across between the parties. Yes, so we'll take appearances. Do you want to start?
Yes, thank you. I'm Madam Chair, Ben Gresson for council for the applicant.
Okay, and you'll have. Do you want your team to introduce themselves?
Yeah.
Yeah, sounds good. Thank you.
Shannon Garden, partner in Glenoir LP applicant.
Okay.
I'm Craig Barr. I'm a consultant resource management planner. There.
Sorry. Kia ora koutou, I'm Paula Costello, I'm a urban designer, consultant for applicant, based in Queensland.
I'm Rob Laurie, landscape architect, based in Christchurch.
I'm Joseph Silver, I'm a local surveyor, working for a local company called Surrey.
Andy Carr, traffic engineer.
Morning.
And Sean O'Doherty, shareholder of 15 National People.
Okay. And did you like to introduce yourselves?
Greg Davis, affected neighbour.
Right, Milgram, neighbour.
Okay.
Alison Milgram, neighbour.
Oakwood neighbour.
Okay. So can I just confirm in terms of who was wanting to speak? We've got Greg Davis down as wanting to speak today. Is anyone else wanting to speak to their submission? No, just Greg?
Yeah.
I'll comment.
Sorry,
I will comment.
you will. You. And that's Mr. Meldrum, was it? Ross Meldrum, thank you. That's so we'll go Mr. Davis and then Mr. Meldrum. And the order of things is we will hear from the applicant team first. They'll present their legal submissions and they'll run through their evidence. We'll ask questions as we go. After that, we'll have Mr. Davis, Mr. Meldrum. As I say, we'll be interested to hear your thoughts and we may have some questions for you. Then we'll turn to the staff and we'll ask them to run through their recommendations, particularly if anything has changed in light of the evidence they've heard. We no doubt will have some questions for you. And we will take a break at some point. We'll just see how the morning flows. Certainly we will expect to finish today. I would expect to finish maybe not by lunchtime, but possibly, but hopefully sort of early afternoon. We are really mindful of the weather. So we'll certainly be keeping an eye on that. We won't be rushed though. It's really important that we take the time and understand the issues for all parties to make sure you have a fair hearing. So yeah, I think that's everything. In terms of is there any procedural matters needed?
The only slight constraint shouldn't be an issue, particularly given the timings you've set out. Mr. Carr just has a flight later this afternoon, but we've arranged in terms of his slotting into the.
Come in fairly early, yes. Okay, fantastic, thank you. We note that there were several late submissions. We are minded to accept those. Do you have any concerns?
No.
No. Any parties have any concerns regarding accepting late submissions? Yeah.
Pretty unfair really in the fact that we didn't get when the submission changed, we didn't get a chance to go in for it again to write their concerns again.
Thank you. You'll have the opportunity to talk to that when you come and have your turn. Thank you. All right. Any other matters? Great. In your hands. Thank you.
The legal submissions were pretty good today.
Thank you.
Those are very read.
Yes, they have. Please do not read them all out.
No, I won't. And I won't. I'll basically go through really the high points and this version. Yes. Apologies.
Thank you.
I'll just speak to as you've set out the issues really that are in contention
That'd be
between
very helpful.
the applicant and both the council officers and the submitters. From a legal point of view.
I might just stop you, Mr. Crescent. Do you want to come forward? We don't have a sound system in the room, so I encourage you to just move your seat forward. It's really frustrating sitting in a hearing when you can't hear. So if you maybe come right round. Completely happy with that. We're not able to change the sound system. So, and Mr. Crescent is speaking quite loudly. So, hopefully that helps. But come on round. That's no problem at all. Thank you.
Thank you. So I've set out at paragraph 17 what Ms. Vitossi has recommended in terms of changes to the proposal. And there's an issue from the applicant's perspective that I think is key for the commissioners in terms of its decision, which is the starting point is the proposal as it's been lodged. And the assessment is whether that proposal is appropriate, both in terms of meeting the 104D gateways and then going on to consider the relevant matters in section 104. And really the two key ones are the effects of the activity and the relevant plan provisions, which we say full weight should be given to the plan change 19 large lot residential zone provisions. And so it's with that in mind that the assessment needs to be, well, is this proposal appropriate? And there is room for amendments to be made to a proposal, but they have to be on the basis that the original proposal will either give rise to adverse effects or that it's not consistent with the relevant plan provisions. And it's at that point that if there's a way in which an amendment can be made to address those effects or consistency with the plan, then that's something that the applicant can be invited to consider. But we say the changes in this case aren't in that category, and it's more around what might be seen as preferable as opposed to avoiding or mitigating an effect and or achieving consistency with the plan provisions. So on that basis, whilst the proposals, the recommended changes haven't been ignored, the position for the applicant is subject to the further amendments that it has made since the 42A report. The proposal as it stands is appropriate and does meet those relevant tests in terms of effects. And
I assume your witnesses will address those specific recommendations.
that's correct.
Yeah.
So the main ones in terms of Ms. Matossi's is will be addressed through, or have been addressed through the urban design and landscape evidence, which they'll speak to in their summaries.
Yes.
And Mr. Carr, which is probably the key one in terms of, and perhaps it's the fundamental premise in terms of the respective transport standards that have been applied, because that really, the issue between the traffic engineers appear to essentially stem from that, which Mr. Carr will speak to. There's one change which, well, there's two really, but certainly one in terms of scope, which is the widening of the access road to essentially include neighbouring land at 157 Dunstan Road, which I submit can't be a change that is either imposed or volunteered, given that land was never subject to this application, was never formed part of the application site.
Can I just ask you about that? So I don't know, can we bring up, could we bring up the plan? Probably the easiest one would be, I think there's an appendix in Mr. Barr's evidence.
Is that a scheme plan?
Yes.
I do have A3.
Oh, do you? That might be helpful. Just so that everyone can see what we're talking to. I should have. Yeah. Okay. So you're talking about the access way as it runs here
That's right.
and the width going into this property.
That's right.
Yes, and what I understand your premise is that the council cannot impose essentially the application site be extended into this piece of land. Is that your point?
That's exactly,
Yes.
that's the submission.
So I'm interested though, because when you amended the application, the client amended the application, they did include land coming down into this site. And so what's the difference from a legal perspective?
So the difference is that the site, for the purpose of the application, we say can be either extended or could always be said to have included what is shown as lot 28, which is currently part of 157 Dunstan Road.
Yes.
And that was on the basis that the AEE set out that portion of the site was to be amalgamated into 155.
Yes.
The The rest of it though, which includes the part of 157 that the road has been recommended to extend into, was never part of the site. So it's a subtle difference in a way, but it is a material difference.
Mm. Thank you.
And then the other, while we're looking at this scheme plan, then the other change, which we say legally can't be imposed, is the amendment of the plan to provide for a road connection to the northwest. There's more of an argument there in terms of scope, and I think in terms of scope, we would be able to probably allow for that change to be made as part of the application. But in terms of imposing that via conditions or otherwise, unless the applicant was to agree to that change, then it's not something that could really be imposed via a condition. That could be if the effects were such that the lack of a road connection meant consent should be declined, then consent could be declined on that basis, albeit we say the evidence doesn't support that conclusion. But a condition essentially asking the applicant to amend its plans and change its proposals is not something that could lawfully under section 108 be imposed.
So, so in your amended plan, you have provided an access, which I understand is to be pedestrian cycleway through on the which is now lot 32.
Yes.
Yes.
Right.
Yes, and if we considered the evidence supports the need for traffic access through to the northwest, if we concluded that evidence did support that or was necessary from an effects management point of view, particularly from an urban design connectivity perspective, would it not be within our ability to impose a condition requiring that? Would we simply have to decline the whole application?
Well, I think what you would have to do, what procedurally, what would be appropriate in that situation would be to essentially invite the applicant to amend its proposal. But it's just difficult to envisage how a condition could achieve that, unless, I mean, it could be as blunt as simply saying provide for road access, but what you're really saying is you need to provide an amended scheme plan under condition 1, essentially, which I haven't seen, again, unless volunteered. It's difficult to see how that could be imposed as a condition. But
And we'll ask your witnesses this, but the access way that has been provided, is that too narrow for vehicle access?
I'm not actually sure of the width, but
Mr. Carr might be able to assist us with that.
he should be able to. And my understanding would be that it wouldn't have been, that would have been built to the extent that pedestrian cycleway access required as opposed to road width requirements.
Yes. Okay, thank you.
And then the other changes.
Just a moment, I'll just check.
All that information.
Thank you.
The other changes relating to further design matters, which was the essentially relating to the configuration, or there's two, so the configuration of the lots in terms of the number of lots on the eastern part of the site, and then the 10-metre setback from the boundaries of the site. Those could be lawfully imposed. Well, you could decline the consent for one of the lots or any number of individual lots, or you could impose a condition requiring a setback. But we say on the basis of the evidence, and Ms. Costello in particular has set out why the setback requirement is inconsistent with the fact that this proposal is in accordance with the large lot residential zoning. So those are evidential matters which we say on the evidence don't justify the changes that have been recommended. Then the final matter was what we see as really a matter of detail in terms of the road treatment and the use of a curb versus what the applicants proposed is more of a landscape related feature, if you like. And Mr. Carr can speak to that, but if that was an issue, we say it could be dealt with and would be ordinarily dealt with by way of detailed engineering approval, which requires essentially a further application, if you like, setting out the matters of engineering detail for the council to accept. Those are the only points I wish to make in terms of the points of difference between applicant and council officers. Mr. Barr has responded to the submitter concerns and appreciate, and Mr. Davis has made the point that those submissions were made in relation to the original application, and a lot of the concerns that were raised were addressed by the amendments that were made to that application. I've set out in the written submissions the issue of the weighting of the two plans, which there doesn't seem to be any issue with between the council and the applicant. But if you have any questions on that point or any other point, I'm happy to address those.
Just one question for you, really just by way of background. At paragraph 43 of your submissions, you are talking there about Glenoir, who has lodged an appeal
Yes.
on the rezoning of the site,
Yes.
seeking it to be rezoned to low density residential, which I understand is an upzone from
That's correct.
from the current large lot. So in terms of the applicant's approach to this proposal, given that appeal, could you just talk through that in terms of the densities that's proposed here, but yet there's an appeal that's seeking a different density?
Yes, it's a fair point. I mean, what's actually happened in terms of that appeal, the appeal is, as you've correctly said, for a low density residential zone, and that was what the original submission on Plan Change 19 sought. Without divulging, without prejudice discussions that occurred through the mediation of the appeal, I can say that the vision for this land has been confined or has been reduced in density from what would be a low density residential outcome to the point where it's more in line with large lot precinct 1, which provides for essentially the densities proposed through this application.
Are there any 274 parties to that appeal?
There's one, but not in relation. So the appeal relates to both the zoning of this land and some council-owned land on the other side of Dunstan Road. There's a 274 party in respect of that zoning, but not the zoning of this.
I do have a question for you, Mr. Gresson. I just want you to, I guess I need to understand the vesting process better, because one of the big issues here, as you started off with, is the width of the access. And you've explained to us that we have no ability to expand that access width, which is obviously a legal confinement. My understanding is that that road is intended to be vested.
Yes.
Now, my understanding of the vesting process, but I'm happy to be corrected, is that that's a process under a different statute than the RMA. So not something that we are dealing with right here and now. As a result of any consent we may grant here, this road isn't automatically vested. There is another decision process that needs to occur to make that happen. And that is basically the council saying, yep, we're happy to take this. So we could make a decision, for example, to say, yep, we're happy for this to be narrower, but in that secondary process, the council could say no.
Well, I'm not sure the extent to which they could say no when, I mean, my understanding of the vesting process that it happens alongside 224C certification, which is effectively the completion of the physical works, including the road, have occurred. And the titles get issued under section 224C, and it's at that point that the council will, not sure if it's an approval, but they will provide for that vesting to occur. I would have to come back to you on whether, if you've got a consent providing for this road to be constructed and vested, whether there's a residual approval that the council would, or a residual discretion on the council's part in that respect, because I haven't seen, and I don't tend to get involved in that vesting process per se. That's more of a property law issue, but I can certainly come back to you as to that question as to whether that could essentially decline at that stage.
I think that would be very helpful, because my understanding is they can. And my understanding in the past has always been that such things as areas to be vested need to be negotiated out before a resource consent is issued to avoid a potential hiccup at the last minute. When I look at the conditions, I think the hiccup might occur at section 223, potentially because of the way the conditions are drafted. So it could be helpful if you could also clarify that to us, because as commissioners, I think one of our concerns, or my concern anyway, would be we grant a consent, go ahead and do all these works, and it hits a hiccup at 224C stage. That's a really poor outcome for all parties, really. So
Yes.
we do need to understand very clearly how that is to work. And I also accept that different councils do that differently, because I have definitely been involved in councils where it can cause a big hiccup, but it may be that CODC, and I will ask the officers later, have a different process for that. So it would be helpful if you could be quite specific to this council in your response.
Yes, no, I'm more than happy to do that.
Thank you.
Any other questions?
Probably. I do have another question for you, which is a legal question. The policy to provide a bore for water on the reserve. Have you looked into that?
Is that which condition is that? Sorry.
Well, it's come up as a result of, I think it was in Mr. Kirkman's report, that there is now a bore required because of, it's to do with infrastructure. My understanding is it's to do with CODC wanting to be able to meter all the water, and they have, therefore, to water your reserve, you have to have an independent bore. And there seems to be a policy. If you don't know anything about it, then I'm happy to take that as the answer.
Well, I think our witnesses, Mr. Soviet and Mr. Barr will be honest.
That's fine. Yep. The other question I have for you is about, there's a policy which talks about public benefit.
Yes.
Can you explain to me what public benefit is?
Well, that's slightly vexed question. That's one of the issues that's always a live issue in terms of appeals on PC 19. I mean, in simple terms, I suppose a public benefit is the provision of land that its immediate use. And this, again, from a planning perspective, Mr. Barber haven't been more eloquent in his answer to this, but I think in terms of providing an immediate use that is not simply for the owner and occupier of the land, it's land in which people other than that confined user of the land will be able to get some use out of that land, whether it's through a reserve, which is probably the obvious way in which land can provide a public benefit. Yeah, I think that's right.
Okay, so it's land, making land available for public use.
Well, it's, sorry, I didn't. what was the
You
second part?
specifically said it's a provision of land, so public benefit is to do with land.
Well, the land's providing a benefit, the development is providing a public benefit as well, in terms of the associated aspects of the development and provision of infrastructure, provision of.
So all those things fall under public benefit. I'm just trying to understand what public benefit means. I've never seen that before.
Well, I
in the
think it must,
policy.
I mean, if you're talking about the public benefit of the development, it's essentially any facet of what you're proposing that enables the public to be able to get a use or get a benefit out of what is being proposed.
So it has to be for the wider public, because it does say such as public access, reserves or infrastructure improvement. So you're saying this is a benefit which goes beyond the subject site. Is that what I'm hearing?
It's not just the subject site, it goes beyond the owners and occupiers.
So it's beyond the owners and occupiers. Okay, thank you. Anything else?
And that's all the questions we have here. Thank you.
Thank you very much. Mr. Garden will go first, and he will prepare a summary.
Thank you. If you could get those electronically to Taryn
Yes, well,
at some stage today, that would be fantastic.
Do you want any of the paper copies, or you just give me an electronic copy later?
Have a quick copy. Oh, might as well have it now. Yeah. Thanks. Thanks, Jim.
What's world? I know, so do I.
Hey, thank you. We're in your hands.
No. So my name again, Shannon Garden. I'm one of 3 partners in Glenoir LP, along with Shauna Doherty, who is sitting behind me, and George Collier. I work in land development. I live projects our own and as a contractor or consultant for others. So it's a development management or project management service that I undertake. Predominantly my work is in Central Otago. I have sort of roots and family here, though we live outside of this district. But as I say, we work here a lot, and Glenoir has property interest here. And specifically these sites at 155 Dunstan Road, and in addition, we own and are separately developing the site at 157 Dunstan Road at the front, and it's subject to a separate consent and development and currently titling process, which I'll talk about.
Yeah.
So we have some experience in land development. It is my profession. The partners in Glenoir have undertaken several projects together. As no doubt is said often in these forums, we endeavour to deliver quality outcomes. We endeavour to understand what the interests of the community are, and to understand how we might serve the interests of the community. We've taken care to formulate and design our proposal at 155 in a manner that we believe makes sense within the zone framework, that reflects the physical attributes and location of the property, and which is also sensitive to surrounding properties. We seek to be a good neighbour. We acknowledge that there are a range of neighbour views, some supportive or neutral, others opposed. Our observation is that a portion of, or the majority of the opposition expressed in submissions, and that we've heard in feedback from neighbours, reflects some discomfort with the zone transition that has taken place away from the existing rural lifestyle use that's established along the north side of Dunstan Road into the large lot residential zoning that now is in place, rather than specifically relating to adverse effects from our proposal. That said, we've scaled back our scheme from what was originally notified, as people have mentioned, shifting from a non-complying 30 lot scheme to the 27 lots plus one, which we have amalgamated in from the 157 site, and so 28 lots in the scheme that you see. And if I might just take a second to, if it were helpful, I could take a second to explain how that's come about.
I've got a pretty good idea of that actually, but what would be helpful is what's the purpose of lot 28? What will you be using that for?
Large lot residential.
So just selling it for a house or something? Yes, okay, thank you. But and I think we've got a pretty good handle on the interaction between the previous application that you're already developing and this one.
And well, so I will state it for the room.
Yes.
So there are 6 lots effectively consented on the 157 site. The 6th lot now forms lot 28 of our 155 scheme. The reason for that is the access into that 6th lot, or lot 28, comes down the access leg in into 155 and through a yet to be constructed right of way along the front edge of the 155 site. And so whilst it is a little bit complex from a sequencing and titling point of view, the sequence that we have agreed to pursue with advice from our surveyors and lawyers is to avoid having to construct access to what was lot 6, now lot 28. We've amalgamated that area, or are amalgamating that area, into 155, and then it will be separately titled as a residential lot as part of the 155 site. So that's what's happened here. Para 4 of that executive summary. So just point out, we are continuing to work cooperatively with neighbours on such things as pine tree removal and trimming, fencing, and of which there will be more interaction. And as we'll talk about a little more through the day, shared roading concepts with properties to the south. And we know we will, and we know we have to continue to engage with neighbours as we deliver a subdivision on this site. Moving to zone intent and character. So we acknowledge that the large lot residential zoning along the north side of Dunstan Road is new, and that we are one of the early adopters or the first applicants seeking to we are, I believe, the first applicant seeking to utilise those comprehensive residential development rules. And you asked previously about public benefit. It's those sorts of things which haven't had the benefit of time and precedent to become established. We believe our application fits squarely within those large lot res zone rules and obs and pols, and will deliver an urban development consistent with the objectives of that zoning. We do consider that council have in the response to our application 42A report and in some of the urban design and infrastructure feedback, sending some mixed messages, so somewhat inconsistent in their application of the large lot residential zone rules. It's our understanding and assertion that we are clearly no longer in a rural zone. So we cannot see that the case, we cannot see that we must therefore be forced to maintain a rural character in what is now a residential zone, as council's urban design peer review proposes. Similarly, nor is that large lot residential zone in typical suburbia. The large lot 1,500 square metre average sizing yields a third of the lots that you might see in a conventional low density residential zoning, as is applicable across the bulk of Alexandria, some 6 lots per hectare. Consequently, because it's not typical suburbia, we would suggest that it's not necessary to establish a conventional gridded suburban block and roading configuration. We'll talk about that further in technical evidence. So I, as an owner and developer, it's our observation, Glenoir, that council's urban designer and infrastructure engineers, in making a number of recommendations, have not yet fully come to terms with the large lot residential zoning that can be given effect. Our scheme, with a mixture of lot sizes and enabling walking and cycling access, is absolutely and fundamentally influenced by its proximity to the township, to a high school, to a primary school, to cafes, and to what is Central Otago's largest and most extensive recreation facility in Molyneux Park. That is a sort of a fundamental basis of how we brought this scheme proposal forward. We think it's highly connected and well connected to the township. We're pleased to incorporate a neighbourhood park into our scheme, as is anticipated under the comprehensive residential development regime. This will convey a sense of openness and encourage neighbourhood scale interaction and limited recreation opportunities for residents. However, it must also be recognised, firstly, that the larger lots that result from the large lot res zoning incorporate private outdoor space for families to recreate. The nearby cycle trail, Molyneux Park, the golf course, and access back to town also and already provide excellent access to recreation and amenity. So in that context, the neighbourhood park that's being offered, we think will work well in conjunction with broader recreation and amenity in the area.
What's your intention for that park? Is there was some mention of perhaps some furniture, but what's your vision for it?
So very much a neighbourhood open space. So yes, there should be some landscaping in it. Yes, that's part of a detailed design process. As I mentioned, as I'll talk to shortly about its function, we don't see that people will travel to this park for recreation and amenity beyond the immediate neighbourhood because of golf course, rail trail, Molyneux Park, schools, other amenity, swimming pool, all sorts of amenity. So very much a neighbourhood amenity, and so some hard landscaping that allow people to sort of meet and congregate and enjoy some open space, opportunity for families to sit and have a picnic, kids to kick a ball, to serve that local neighbourhood.
So are you thinking seating, or are you thinking play equipment, or what are you thinking?
All of which is, yes, possibly, but we simply haven't gotten to a detailed design process yet to determine that. That comes once the consent's issued, once we get into those detailed design stages, and once we engage with council on the engineering approval process. We've had an initial discussion with council's parks people, but as that will vest in council, ultimately we need to take a steer from council's parks people as to what goes in there.
Yeah,
we can construct it, but it has to be something that council fits council's policies and that is appropriate for them to maintain ongoing.
okay.
Roading and connectivity. So addressing this business of the entrance and the width, council's recommendation to widen the entrance corridor to 20 metres is opposed. We oppose that. As we will discuss further, the entrance configuration, i.e. the cross-section of an entranceway, incorporating carriageway, a significant dual-purpose walking and cycling access path, infrastructure in that corridor and landscaping is adequately accommodated within the available 15 metres. So there is no physical constraint. In the feedback in the report associated with the 22A report, Council's infrastructure engineer seems to acknowledge this. There is no requirement nor provision for parking within that corridor for reasons that we'll talk about further. And in summary, there are no identified effects that warrant taking another 55 metres into that corridor. In terms of background, we've had multiple prior interactions with Council's infrastructure personnel on roading configuration for the scheme as a whole. That widening recommendation was never previously brought up. There were a number of other matters that have been canvassed. I've set out a bit of communication history in the owner's statement that I provided. Glenoir has consented and is in the process of titling, so have gone through the 223-224 process and lodged with Lynn's titles for the 157 property. As part of that process, lots in the adjacent 157 property next to this entranceway have been contracted for sale. And so it's not necessary, nor in fact is it feasible to increase the width of that entrance road.
Sorry, I just to clarify that you're saying where are you at in that process? You haven't got title yet, but it's with Lynn's. Okay, thank you. Yeah.
The road connection to the northwest through into the Meldrums 165 Dunstan Road proposal. We do not support that. We are not offering that. We consider that no clear case has been made for requiring it. And I'll talk about that more in my own statement. We note that the 165 block to the north does have direct access onto Dunstan Road. And again, referencing this yield or the scale of lots that result from large lot res at 6 lots per hectare. It's our view that you don't require and don't need gridded blocks with rear roads. Indeed, we would have a concern, it's somewhat a motive language, I grant, but we would have a concern about creating rat runs in behind Dunstan Road, which simply aren't necessary. Those rat runs should be avoided unless there is a clear case for them. And I mean, we have had some engagement with the Meldrums granted, but we note that they are an opponent to our proposed development, and we have not had any discussion with them about that access. Conversely, we have a different situation.
Can I ask a question on that? So, from my read of the urban design evidence from the council, it was the connectivity recommendation relates more to avoiding sort of a long sort of individual development here and then another one and then another one and then another one where everyone comes down and onto Dunstan Road rather than connecting in within that community. Do you accept that if at some point in the future 165 Dunstan Road was developed in a similar way to this site, do you think there would be some community benefit by having some connecting roads between those properties and then of course across into 147, say, so that there is some connection further back from Dunstan Road? Do you, from a community sort of connectivity perspective?
No, because of the yields. So if this was typical gridded 400 square metre lots, then from a spatial arrangement, you need street frontage. Here, what's going to be happening is there is no purpose for people to be driving sideways between properties, or sideways in that area off Dunstan Road. All of the traffic activity that will occur in that area, I would suggest, and Mr. Carr can talk to with more expertise, will be to come out onto Dunstan Road and go and do something beyond that. And so then you have to sort of take on that sort of yield and the scale of lots and the amount of traffic, you have to figure out what's the best way to serve that. Now, if you believe that some way or other along that Dunstan Road frontage, granted that council want to minimise the amount of traffic, the amount of access ways, but there will be crossings on the 165 property and other properties out onto Dunstan Road. You could argue the converse, that rather than having 3 or 4 crossings on the 165 property, there should be one, and it should be a vested road. So I don't buy the argument that you've got to direct all the traffic sideways in the back of those lots rather than bring them out efficiently onto Dunstan Road.
Okay.
And look, it's all conjecture. This things like a structure plan would have helped this. Council have opted not to pursue that. And so there is a bit of a sort of an ad hoc nature to how this stuff comes to the market, as development comes to the market. Well, we would say, unless there's a compelling case, don't create roads that you don't know that you need.
Follow-up question there for you is, you've stated that the council decided not to have a structure plan. Do you have any insight into any of the discussions around
And
it?
insight.
Okay, would you be able to quickly summarise perhaps why that was not decided upon?
I think I'm reluctant to, because it's a very separate, it's a plan change zoning process. We have a strongly different view to council. You know, it's not a subject for today, I don't think.
Okay, thank you.
You might be coming to this, but I'm interested in the connection you're proposing to the south east.
Yeah, and just exactly about to come to that. So, we have had interaction with our neighbours to the south. There has been support for that connecting road, and perhaps the key differentiation there is that the property that we are proposing to put a road stub to is otherwise landlocked.
They take access off, that's 149 Dunstan Road you're talking about, and they take access up is it an easement they take?
Right.
Is that right?
So that's part of the 149 property,
Yes,
but there's not the width there to vest that as a road.
I see.
And plus that right of way is served by, it is, so the 147 property and the properties behind utilise that right of way, and all those parties would have to agree and come to an alignment. And so you've got other forces beyond your control as to whether the 149 property could develop, subdivide and access. And so that's not a suitable vested road access without a whole lot of neighbour agreement or indeed a structure plan.
Yeah. Karen, could we get up, do you have a map which has the property addresses and the district plan zoning? Or is that two different? I might keep going, but it'd be useful to have that up just
Yeah.
for everyone, because I've got the district plan maps in front of me, but I appreciate others won't. Here we go. She's a machine.
I wonder if I say something.
No, you'll need to wait until your turn. Thank you.
It's not super big and
That's the 155, and then, that's good.
is that enough?
Yep, that's fine. And then behind that, we've got 149.
I don't think I can get my bar at the bottom to go. Oh, it's a little bit better.
Yep, no, that's good. That's fine. Do you want to hop up and just so the room is, you can.
Give me 1 second. I just need to share this. So if there's anybody online, they can. Probably about as big as I can get. Is that okay? Can we kindly?
Yeah, well, I can certainly see that. Yeah, do you want to just take us through, run us through that again, just pointing out the property so we're really clear? Thank you.
Okay. So in context, we've got this boundary here below one to the southeast of 131 is the start of the large lot rezoning.
Yes,
This remains rural with existing use rights. And so we're coming up our large lot strip up here. So we've got that property, we've then got 147, 149, and then we've got our 157 and 155. The road stub that we are proposing comes in here,
yes.
with the support of this neighbour. And you can see, or it's very difficult to see at the scale, perhaps from people in the room, but this wee corridor that my pen is across now is part of the 1449 title. It is used for access by the properties to the rear, which the status in the room is one.
Mm-hmm.
So it serves as a right of way, and the width of that isn't adequate for a vested road. So in any further development of that, you know, if you don't have the support of your neighbours, you're not going to be able to do anything with this property. So in that sense, from an intensification from its rural lifestyle use today into the use intended by the large lot red zone, it needs a vested road access, and that's how we're delivering it.
Thank
So
you.
That's
No, it's helpful,
for
thank
a
you.
fundamental difference between those properties.
Thank you.
So as we have onto paragraph 15 of the executive summary that I've provided, as we have sort of wrestled with and sought to give appropriate regard and effect to the comprehensive residential development rules, we've willingly and happily incorporated this neighbourhood park we've spoken to, and as part of that evolution, we do acknowledge that there is a case for walking and cycling connection, and that sort of also links to the question you asked before about what do we think the use of that neighbourhood park would be. Well, at a walking or cycling distance, yes, local residents from around that neighbourhood could come and utilise that park. I don't, however, believe that people would hop in their vehicles and travel to that park at that scale with that amenity, with all the what's going on outside of our site. So we've revised our proposal to provide that walking linkage towards 165 Dunstan Road. Improves access to our local park, and also, we think importantly, it enables the aggregation, the potential aggregation of pedestrians and cyclists through that, into that new vested road within 155 and down that 3 metre wide shared cycle and pedestrian path that we are proposing down our entrance onto Dunstan Road. What Mr. Carr and others will talk to later on the day is this sort of relationship of the properties in the area on the north side of Dunstan Road, the functioning of Dunstan Road, and how people get across the Dunstan Road to the rail trail corridor on the south and that amenity. That detail has to still be worked through, but we believe it would be good sense to, and we anticipate that there will need to be pedestrian crossings across Dunstan Road, and so we are in favour of that being somewhat concentrated and aggregated in the vicinity of our entrance into 155. Now, Mr. Carr will talk about there is a fair bit of design detail to work through as to how you enable an appropriate traffic intersection with pedestrian access, but we believe there's an opportunity to aggregate pedestrians and cyclists down that large 3 metre wide path that we are proposing in our entrance towards Dunstan Road.
Great, thank you. I just have one further question. So so in your amended proposal, your lot 31, which is the pedestrian cycle link,
Yes.
to would link to 165.
Yes.
So you've got that as a local purpose reserve walkway. That presumably also will have vehicle access for lots 5, 6, and 7. Have you got the scheme plan?
Yeah, I could sort of draw a larger version of what we think.
No, so my question is, you've got the access here,
Yes,
presumably you've got vehicle access here, here. That's their frontage,
correct.
yes, but if in the future this area was developed, it would just be, how would you control any cars getting through that way?
Yeah, so there's a small green line that crosses towards the back. So
Yes,
at the point by where that black arrowhead is,
yes,
at the point that you no longer needed vehicle access, one of the things that you, as a design sort of arrangement, you would want to ensure is that you weren't just creating car parking, and so you would transition from a concrete right-of-way configuration to vehicles into bollards or some such barrier that enabled the walking and cycling access through, but not vehicles, and then you would transition down to a narrower path, ideally with a wee bit of landscaping, ideally, well, certainly taking into account the septic things of not creating these pokey little alleyways. So that have to be thought as to the fencing on either side, giving some visibility, but balancing visibility and privacy, those sorts of issues between lot 6 and 7. So we certainly wouldn't design for traffic to be able to get past that green line.
yes, and we can obviously ask Mr. Meldrum, but presumably, certainly in the foreseeable future, that would just be fenced off.
And
Assuming you don't.
it may, so we would have to take some careful decisions about when indeed it was even constructed. So do we construct it now? Do we not? Is it simply a provision? So if you look at the road stub on the other side that is proposed, that road stub, of course, won't be constructed until it's needed. Do we take some of that thinking into account on a pedestrian access? So you said that.
Yeah, so what would you just leave it as, well, just grass it or something?
Yes, possibly even you might only fence on one side and allow that area to be occupied for a temporary period of time by one or other resident to make sure it's maintained. So one thing you don't want to have happen is it just is a sort of forgotten out
Wasteland.
grows weeds. So there'd be the combination of sort of legal framework and covenants and all those sorts of things to ensure that it was able to be given effect to at the time where it was needed to.
And we'll ask your planners around whether there's conditions are appropriate now for that.
Yeah.
Great. Is that all you had for us?
Just a final handful of comments on what I'm calling condition inflation, and as Mr. Preston touched on the timing or the need to get into consent conditions, which are really matters of detailed design, which we haven't thought through. So we would seek to avoid overly prescriptive conditions of consent for matters that are best dealt with through the detailed design and engineering approval stage. And I'd specifically touch here on the notion of a bore. Now, we acknowledge that if we're providing open space, there will be a need for irrigation. However, a bore hasn't been contemplated or discussed or planned for prior to it being proposed as a condition via the Section 42A report. We're not aware of any precedent for this within the district. We haven't had the opportunity to evaluate it. We don't know where it would go. We don't know how it would be constructed, to what spec, how it would vest, and what arrangements would need to be put in place. Why that's a better option than continuing to use water out of the reticulated, admittedly domestic potable water system. So until that's worked through, we propose something of a more general nature, a condition that anticipates appropriate irrigation, but not necessarily a prescription about a bore. And touching again on this matter of the 10-metre setback that's proposed, we would like to avoid bespoke restrictions that on conditions that impose bespoke restrictions that are inconsistent with the large lot residential zone rules.
Okay.
Thank you.
Do you have any questions?
I have no questions, thank you.
Just one question. Thank you, Mr. Garden. I wanted to take you back to your comments earlier at paragraph 6 of your summary.
Yes.
And it relates to the zone intent and character. So you've noted here that you're clearly no longer within a rural zone. So it cannot be the case that we must seek to maintain a rural character. So I see what you're saying, and I understand that this site is within that large lot residential zone. And we'll be talking through this with Mr. Barr and from a planning perspective. But in terms of the eastern block of the development that does sit within a rural residential zone, how have you considered and approached the design? I guess what's been paramount in your mind in terms of how that might, sit within that rural resource? Because council does have some discretion to consider that wider amenity and character.
Yeah, could you just clarify when you say the eastern section, which?
The block that juts out.
Yes.
Yeah.
Yeah. Sure, so the I think we've been quite explicit in our scheme to respond to that by placing larger lots towards the back. So the smaller lots within the scheme that we propose are on the flat and the lower piece of the property. If we do just for a second take this combined view of how we have consented and are developing 157 alongside of 155, it's you're not 157 is out of your scope, but I would note that we have all of the lots that we've subdivided at consent and title on 157 are in excess of 1,500 square metres. So recognising that it is a desirable thing to maintain the sense of spaciousness, that's the zone character from Dunstan Road. We've organised those larger lots at the frontage of Dunstan Road that will be experienced by people in the community driving by. And then we've had some concentration of lots, and we strongly believe, as I put in my owner statement, didn't talk to today, that communities should have a variety of lot sizes, a variety of types of family arrangements, and so just homogenous 1,500 square metre lots is not what we seek to deliver. So we've concentrated that a little bit in the lower part and the centre of the site, and then as we get towards that back piece, we have made those lots larger quite deliberately to sort of speak to the question you're asking.
Thank you. And so am I correct in understanding that the bespoke provisions you're concerned about don't relate to these, but they've not been suggested to be imposed on these sites?
I'm referencing there to a notion that we should have to be subject to a 10-metre boundary setback when there's nothing sort of on an effects basis or a sort of an evidentiary basis. There's nothing about what we're doing on our side that's any different from what anyone else in the large lot red zone would be doing.
Right.
And so if that 10-metre setback were appropriate, then it should have been part of the zone. It's not just imposed as a whim on an individual property.
Thank you. That's helpful.
Thank you very much for your
Thank
evidence.
you.
Thanks for answering our questions.
Looking at the timetable in front.
Yes,
of the
it does.
I'm with on that.
Yeah, I think we'll have Mr. Carr and then we'll take a break after that. Since we've been talking for a break, it'd be good to.
yes.
Thank you.
Thank you.
Yep, in your hands.
I have the main set of evidence that was pre-circulated and which has been handed out to the 3-page summary of that.
Thank you.
So I shall skip over that, and in the course of doing that, I'll answer one of the questions that Commissioner Baker answered this morning as well.
Great, thank you.
So my
Could you speak up a little bit, Mr. Carr?
sure, yeah.
Thank you.
I usually get told to be quiet. My name is Andy Carr. I previously prepared a statement of evidence in respect of transport matters in respect of this application. And my evidence and my qualifications remain as set out in that statement of evidence. Within the statement of evidence, I assessed the proposed transport networks associated with the subdivision against relevant land development standards. Of relevance is that the council's current 2008 Land Development and Subdivision Engineering Code of Practice is based upon the 2004 version of the overarching national standard. But the 2004 version was withdrawn and replaced by a newer version in 2010. The 2010 version remains current, and the council is presently migrating to this. So the approach that I took in my letter report was to review this proposal against the 2010 standard. In my assessment, I identified a small number of minor non-compliances with the 2010 version of the standard. But in my view, these were not sufficient to give rise to adverse effects on road safety or roading efficiency. I also noted that the Dunstan Road site access intersection can be designed to meet current standards and guides, and the traffic flows are such that efficiency or capacity issues are highly unlikely to arise if it's designed as a priority and give way type of intersection. I consider that provisions should be made for pedestrians and cyclists to cross Dunstan Road to support the use of the rail trail and reduce the need to travel by private car. There are various locations where such crossings could be installed, but due to the extent of rezoned land in the area, I consider that road crossing opportunities should be provided in a coordinated way. In my view, the provision of such a strategy is the role of the council, although I'm advised that the applicant is willing to offer a condition of consent to ensure that appropriate crossing facilities are provided on Dunstan Road, either through constructing a pedestrian refuge or by making a financial contribution to the construction of a refuge elsewhere and providing connections between the site and the crossing. The provision of a strategy for road crossing opportunities and also the reduction in the speed limit that I also discussed in my evidence, not, in my view, reasons why the application cannot be supported. I read the submissions made on the application and was able to identify only one transport-related matter of concern, and that was relating to the connectivity to adjacent areas. I consider this has now been addressed through the provision of a walking and cycling route between the site's spine road and the northern site boundary. I read the council officers' reports, particularly that of the council's senior land development engineer, Mr. Kirkman. As I mentioned before, a point of difference between my approach and that of Mr. Kirkman is that my assessment is based upon the 2010 version of the national standard. Mr. Kirkman has used the 2008 council guide, which is based upon the superseded 2004 standard. That leads to him identifying a number of matters that, in my view, are actually addressed within the most recent version of the standard. I've considered each issue raised by Mr. Kirkman, and I'm not of the view that the proposal as lodged would create adverse outcomes. However, a small number of changes have been made to the proposed layout in order to respond to a number of Mr. Kirkman's comments. Having assessed the proposed subdivision layout with regard to transportation matters, I'm of the view that the proposal will not give rise to adverse road safety effects, nor adverse effects with regard to roading efficiency, and consequently, I remain able to support the proposed scheme. And in my view, there are no transportation reasons why consent could not be granted. So to double back to my paragraph 8 and the small number of changes that were made to the layout, and to Commissioner Baker's question about the width of that walking and cycling route that's proposed to the northern side boundary.
That was my question.
So,
Yeah, that's fine.
it's 6 metres wide.
Okay, okay.
And it serves actually as a good example why the use of the 2008 council standard versus the 2010 national standard is important. So within a 6 metre legal width, the council's 2008 addendum says that that's only sufficient for a right of way serving 4 properties. And within that, it's expected that there is a 4 metre wide traffic lane. When you get to 5 residential properties, that legal width jumps up to a 12 metre width and a 6 metre formed roadway and a 1.5 metre footpath and 4.5 metres width of berms. So the change in the busiest hour from 1 vehicle every 15 minutes to 1 vehicle every 12 minutes gives rise to an additional 6 metres of legal width being required. If we look at that same scenario under the 2010 version, the width of a 5.5 metre wide formed width is sufficient to serve 20 residential properties, and there's no need for a footpath because it's deemed at that point traffic flows are so low that pedestrians can share the road safely with motorised vehicles. So there's a big step change between the 2004 national standard and the 2010 national standard about the capacity of roads, where the council standard is based upon the 2004 version, which prioritises footpaths, for example, even under very, very low traffic flow conditions. Whereas the 2010 version says, yeah, when you've got even 20 residences, it's okay that pedestrians can share the movement lane with vehicles. So to answer the question about whether the road could fit within that, the answer is it depends. If there's a bit of flexibility around the council's standard, the council's addendum, you could certainly, within the 6 metre width, put in a 5.5 metre wide roadway, putting 250mm berms on either side, and then expect that pedestrians and cars share the same surface. And that would meet the 2010 standard, but it would be well outside of the 2008 council addendum.
Okay.
That's all I have.
That's we had. Okay, great. Thank you. I have a couple of questions. In terms of the different standards applied, have you done many assessments in Central Otago District?
I have done some, yeah.
And what's your experience about which standard is applied?
The one that comes to mind is the redevelopment of the old Cromwell Holiday Park, where that was progressed on the basis of a design based upon the 2010 version. That was given resource consent on the basis of the 2010 version. When it came to the vesting of the roads, the council required that those roads were redesigned in order to meet their 2008 addendum, or the roads would not be vested.
Well, I think that's the point that Commissioner Baker's making. Yes.
And that then ultimately meant that that particular applicant had to redesign the roads because they wished to have them vested.
Can you clarify for me at what point that was raised? Was that at 223?
Council, my recollection, it was a little while ago. My recollection is that the council opposed the subdivision on the basis of it having been designed under the 2010 version. At that point, to be fair, the council had not indicated that it was moving away from its own addendum. It's only in the last year, I think, or 6 months, that the council has indicated that it's updating its addendum document. So the prevailing circumstances were slightly different. But the argument at that point was that the 2008 council standards were out of date. We have designed the subdivision to meet 2010. Council opposed it on the basis that the road should be designed to the 2008 addendum. The commissioners agreed that the 2010 version was the appropriate design standard. When it came forward for engineering approval, the council said that at that point they wanted to be redesigned.
So I think I can answer that in terms of the sequence as to when that, it's that engineering approval stage.
Mm.
And that is certainly my experience in Queenstown.
And then, sorry, just to finish that off, so in that case, is it your understanding that that subdivision was redesigned to meet the old standard?
Yeah.
So did that at that point, and did that have an impact on the resource consent? Have to go back and vary it or something?
Involved at that stage.
That's very helpful. Thank you, Mr. Carr.
I have a couple of other questions. So at 48 of your evidence in chief.
Yeah.
And you're talking about, as I read it, I understand you're talking about the area at the, sort of northeastern part of the site,
Yeah.
lot 16 through to 22. And in the middle sentence there, you say, however, I highlight that the proposed pattern of lots around this access or cul-de-sac extension means that the roadway cannot be extended in future and so does not support future growth. Can you just explain what you mean by that? Just
So it's in response to the comment Mr. Kirk made, talking about the extension of that right of way. Or at least at high rate, the extension of that right of way to serve additional land in that area. But my response to that was that the land on all sides of the probably on the screen. The land on all sides here
yes,
is not zoned for a more intensive use. And
Yeah.
so the extension, the formation of this as a road
yes,
with a view to extending it to serve this area is, in my view, not a relevant consideration because there is no land, there is no development here that it would serve. And it would be forming a road all the way through for no particular reason. When the council's own addendum document does identify that rights of way are a suitable mechanism for serving residential property.
And at 49, you've said you don't support the proposed condition which requires that there is the cul-de-sac be extended. And the elimination of the right of way. So my understanding of what the recommendation is that cul-de-sac would essentially extend up here somewhere, and you don't support that. Is that
The recommendation is that that's right. The road, the legal road, will extend further towards the northeast.
Yeah.
The rationale for that is to quote better serve community outcomes unquote. But I don't understand why that would be the case. But I also don't see a case to say that a right of way has to be eliminated to form a road when even under the council's documentation, a right of way is an appropriate roading solution.
Yeah. And can you think of an example where you might recommend that a cul-de-sac did need to, like in what situation would it be necessary or appropriate to have a cul-de-sac sort of extending further? Is it if there were more lots, or what situation would apply?
So I think that the issue then becomes the number of lots served by the right of way. If we were looking at a large number of lots being served from a right of way, then a road becomes the most appropriate solution.
And what do you have what number would be appropriate in your mind?
The usual rule of thumb is 6 or 12, but I've never managed to drill down into it.
6 or 12, that's quite a bit different.
Well, it's it says 6 lots in the new standard,
Yes.
but the problem is that some lots can have more than one dwelling on them, which then leads to 12 dwellings.
I see.
So that would be one scenario. The other scenario would be if the land around it was upzoned. and there were intents to develop that being an access point.
I think. And in this case, am I understanding you correctly that the intention now is to access 5 lots off that right of way,
Yes,
and therefore that does meet the 2010 standard, is that right?
so it is well within the 2010 standard, and it's one lot more than the council's addendum. Council's addendum maxed it out at 4.
Can I just ask a follow-up
Yeah.
question on that particular right of way? Mr. Barr in his evidence has referred to you in saying that there are no constraints in terms of servicing. Now, I actually think Mr. Barr's made a mistake and should be referring to Mr. Sobeck, but I'm just checking whether your expertise extends to infrastructure and right of ways, and I'm assuming it doesn't.
No, it doesn't.
No, thank you.
And to 2 more for you. So at paragraph 56 of your evidence, and she.
Mhm.
So we talked a little bit to Mr. Gardner a little about his intentions with the links between the properties on each side. From a traffic point of view, what's your view about any benefit of providing vehicle access connections between the sites, within the sites, as opposed to relying on Dunstan Road?
Without digging into the structure plan issue,
Yes.
I would say that if a person was living in that area, you would look up the reasons for their travel, and their reasons for the travel is generally education and employment, travel to school, travel to work. All of those movements would be more efficiently carried out by residents moving on to Dunstan Road and then using Dunstan Road to travel to those locations, or using walking and cycling because of the high level of connectivity, the high level of proximity to likely destinations that people might want to go to.
Mhm.
Which then leaves a sort of a north-south movement within the site being very limited. And I would say it's probably just people visiting their neighbours. And that being the case, the traffic volumes are all going to be very, very low. And I would at that point say, well, is it worthwhile providing a road? Maybe. Is it worthwhile providing 20-metre wide road reserve? Absolutely not. That's not an efficient use of the land. So I would say that the case for a road is sketchy at best. But if a road was to be provided, it should be fit for purpose and not over-designed or land taken just because it's going to have nice wide berms, which provide no transportation benefit. There might be other benefits for urban design or landscaping. I can't talk to that, but in terms of the transportation function, a narrower carriageway fitting within a 6-metre wide legal width would be adequate, I would say, for the scale of development that could be expected to happen.
Thank you.
To ask a follow-up question on that, Mr. Garden, and he said it was somewhat emotive language, but referred to this potentially becoming rat runs. Would you consider that a risk, given that they're, I mean, assuming it was in this location, they're quite offset from each other?
I wouldn't say a rat run is a likely outcome. Rat runs happen when drivers take a route which is not suitable, but they take the route that's not suitable because it provides them with some sort of speed benefit. I think if we were talking about a 8-metre wide flat road within a 20-metre wide road reserve, yes, there would be rat running, because at that point people will accelerate and they'll get to high speeds. But if we adopt the approach that's set out in the 2010 standard of saying that roads need to be constrained in order to reduce vehicle speeds, then if this walkway to the northern boundary was formed as a road, we would find low vehicle speeds, and people would then drive out to Dunstan Road on the basis of that end of the route, subject to that site having access onto Dunstan Road. If the council's view was to try to limit accesses onto Dunstan Road by funneling all the traffic down narrow roads, that would be a bad transportation outcome.
And at 54, I just want to check that this is correct. The first sentence of para 54. The bulk, you've got the middle of that sentence, the bulk of traffic movements will be between the sites and the west or southwest, the direction of Alexandra. Is that correct? Alexandra's to the south of the site, isn't it? Or have I misunderstood your paragraph?
It is to the south, but the movement will be towards the southwest because that's the orientation of the spine road.
Sorry,
So
take me through that. So you're
really,
You're just,
you're just talking about going that way.
People in Keystone
Yeah.
will go that way.
Oh, I see. So I thought you were meaning they were heading off down Dunstan Road this way, but they'll be going that way.
They'll be doing.
There and this way. Okay, no, that's good. And then I have just a final question, just back to the standard. You mentioned that it's your understanding that council are reviewing their standard, and we can obviously ask the council staff about that. What's your understanding about where that review is at?
I don't know. I have heard that Mr. Coachman will be able to simplify further details.
Okay.
But my understanding is that the note on the council website in there for about 6 months.
That's and says.
It basically says the council is reviewing
Okay.
standard, but I
Yeah.
would have thought, given the importance of standardisation and presenting drivers with a consistent roading environment, I would expect that the council will be progressing that with some urgency. It would be unusual for a standard to be disregarded for an extended period of time.
Well, isn't it a 2010 standard?
Yeah.
So,
Yeah.
Okay.
Can I have a clarification that in the appendix to my owner's statement, we have email exchanges referencing minutes, referencing meetings with council about those changes in standards.
Thank you. Anything else?
yes, I just wanted to look at condition 19 in Mr. Barr's evidence with you, Mr. Carr, if you can pull that up.
Yeah.
So condition 19 is about the intersection and diagram E. And Mr. Carr has removed the final part of that. I just couldn't find in your evidence where he had pulled that from.
That was a conversation that we had. The reason for that is the formation of the road is something that, in my view, is better dealt with through engineering approvals.
So you're not saying this is necessarily not needed, you're just saying that's something we should address, or we shouldn't address now, that can be dealt with.
I'm saying it's something that you don't need to turn your minds to. It's something that will be dealt with through the engineering approval process.
Okay.
Actually, still we're on conditions.
Yep.
Have you reviewed the conditions as recommended in Mr. Barr's evidence?
Yes.
Yes. And are you comfortable with the amendments that he's suggesting to the conditions, which were a starting point from the 42A?
I don't recall that I wasn't comfortable, but I don't recall it. I didn't go through and tick each one off as I went through because it was still a work in progress when Mr. Barr and I were discussing it.
Okay, well, we may ask you to do that, but we'll see where we get to in terms of conditions by the end of the session.
There were certain things that are conditions that are unusual. So, for example, condition 22, not within the remit of the resource management factor set speed. That's in the hard way. Environment Court judge. So a condition that's, I
Oh,
think, okay, the 40 kilometres an hour is ultra.
Although
No, that's not recommended by Mr. Barr to be deleted. Are you saying that you don't support the condition?
I'm saying that emerged from the council and but there's a review process, I think, that needs to
Okay, yeah,
work out.
you're totally correct. Yeah.
As an owner, we have no objection, hence we didn't delete it. But
well, it'll be council road and it'll be council's speed limit, so I'm not sure that, anyway, we can look at that. You might like to address it in your reply. Thank you.
Just a couple of
Yeah.
really minor questions for you. The curb and channel issue and, sorry, there was another one. The curb and channel issue, you have said, I agree with the overarching principle of Mr. Kirkman's comments that there needs to be confidence that motorised vehicles will not intrude into the shared route. You've also said the curb and channel issue is better dealt with at engineering approval stage. I understand that. Would it be appropriate to include a condition which indicates that this intention should be achieved so that motorised vehicles should not intrude into the shared route?
Yeah, that would be pragmatic. Yeah.
Okay, and I think there was one. Oh, rubbish bins, that's the other one. So yes, always comes up, seems to be the topic of the year.
Yeah.
So the right of way and rubbish collections.
So
Does the standard NZ for 2010 say anything about that?
no, it doesn't turn its mind to refuse collection. So what would normally happen for a right of way would be that the owners move their rubbish bins to the end of the right of way, and then they are picked up by the refuse vehicle on its way through. So the refuse vehicle pass through the vehicle through the site, would be along the spine road, turn around, turning head and come back on itself.
So have you reviewed if this turning head has adequate provision to allow for all the wheelie bins that this council has for an extra number of allotments, as well as obviously allotment probably 23 and 15, so probably 1, 2, 3, 4, 5, 6, 7, probably 7 or 8 allotments would need to put their bins on that turning head?
So what tends to happen is people just put the bin out, it's first come, first served, as to how close you get to your property, and people just move along the road. It sorts itself out in practice. It's not, it's unusual to have specific provision for particular bins. It has happened from time to time in Queenstown with putting in concrete pads and the like. But generally people just move the bins out and then they just move them along the road. As and when.
Yes.
No, thank you.
Right, thank you very much for that. Thank you for answering our questions. Are you able to stay in the hearing? I know you've got some time constraints. It would be helpful, if possible, for you to hear our questions of Mr. Kirkman, because I think it would be interesting and we may need to come back to you with further questions.
I need to leave at lunchtime to catch the flight.
Okay. Possibly an issue then. Well, we'll have a chat at morning tea and maybe rejig our order of questions. We may ask Mr. Kirkman to some questions earlier to deal with the traffic issue. But if you could hang around at least for the next sort of bit, is it? Yeah.
And if my flight is cancelled because of work.
You'll be hearing again. Great. Okay. Thank you. So we will adjourn. We'll take 15 minutes and we'll be back at 11. Is it Mr. Kirkman? Thank you. We'd just like to ask you a few questions around the traffic matters, just so that we can close out that traffic issue now. And then we'll come back to you later on the other matters.
When his car's starting, he's just moving his car. Reparking the hours on.
Oh, I should have done that too.
Oh, probably mine's getting a ticket as well.
I know I'm gonna sorry.
Yeah, well, we're reconvening. So what would be helpful if you can just explain to us your understanding of the standards that Mr. Carr is referring to in his evidence, and your opinion about which is the most appropriate and for us to consider. Thank you.
Sure. I wrote a page on this yesterday.
Great.
The most recent New Zealand Standard 444 for land development and subdivision infrastructure was published in 2010, making it 15 years old. The Council's Code of Practice was published in 2008, making it 17 years old, 2 years older, and customised to the specific requirements, design, character, and functionality of our district. The Code of Practice 2008 has been explicitly referenced and with occasional well-justified exceptions has been enforced in every resource consent application for the past 17 years. As anyone who's dealt with CODC land development knows. No grey area. The CODC Code of Practice is an amalgamation of the NZS 444/2004 and the custom written district specific policy captured in the CODC Addendum July 2008. So the 2010 release permits a narrow road width than the CODC Code of Practice. This means that 2010 supports higher levels of urban intensification. It is the position of CODC and numerous other low density councils around New Zealand that without modification, the 2010 version is a suboptimal code. The 2010 code applies well to those places around the country which require denser development, the likes of Auckland, Christchurch, etc. However, adopting 2010 without amendment leaves districts which have not reached the limits of urban sprawl and where plentiful land is still available for development in the position of being subject to rules that were not intended for them and are forfeit. Noting the philosophical design differences between the two versions and having only written their own customised version 2 years prior, it is little wonder that CODC staff of the time chose not to adopt the 2010 code. Nonetheless, CODC have this year started the update process and look forward to adopting a 2010 based Code of Practice at some time in the not too distant future. But I stress we will not and have not ever claimed to be intending to adopt 2010 without significant amendments. Such a customised approach is critical to ensure our district-specific constraints and goals are adequately captured. CODC, like many councils, have created a custom Code of Practice based on the 2010 version. You'll notice CODC's version is a lot larger than the original 2010 version. CODC's eventual 2010 base code will be similarly modified. Introducing a new code of practice is no small task. And thus far, the most controversial and hotly debated aspect of our growing 2010 based draft code of practice document has been the requirements in the roading standards table, including road widths and a number of lots coming off rights of way. Noting the meetings held so far and the unique desires and demands of our district, I can assure the commissioners that a wholesale adoption of 2010 roading standards will not be found in a future CODC code of practice. Rather, a new set of district-specific rules will be introduced that will likely represent a middle ground between our current code of practice and the dimensions and criteria provided in the 2010 code. Claiming the council's adoption of a code of practice standard has little authority because the applicant prefers another standard is analogous to claiming to a police officer after being pulled over for speeding that the speed limit is not applicable to you because you prefer the speed limits in a different part of the country. I would also like to encourage anyone who is interested in the status of land development code of practices in New Zealand to educate themselves on the difference between superseded and withdrawn. Operating a withdrawn standard would be highly irregular and not something CODC would entertain.
Thank you.
I do have a question for you. I take your points and I accept that there is, I do a lot of work in QLDC. I'm very conscious of that particular document. What you have said is it's likely to be a middle ground, which would be the most logical outcome. What I don't see in your evidence that you've presented to us is an assessment of whether this is the middle ground. And in terms of the two issues which I see as the key issues here, which is the width of the access to the initial access road and the width or the number of allotments of the right of way. So I'm just interested in your view as to whether this is not actually middle ground, because these are obviously, or at least I wouldn't see these as extreme cases. These are not extreme divergences. They're not pushing the bounds of NZ 4404 2010. They're actually just somewhere in the middle. So can you speak to that, please?
Sure, and as Shannon knows, we've been advising applicants for the last 6 to 12 months that we will entertain arguments to bend the rules of our current practice based on good justification, and meeting the requirements of 2010 can form part of that justification. Some people have unfortunately misinterpreted that to just say, well, we've met 2010, which is certainly not the message we're sending out. It's that can form part of the argument, but you still need to have a good case for getting an exemption from our current rules. So for this particular design, we're still operating under our current code practice. Our 2010 base plan has not been resolved, and when it is, as I say, I don't know where that middle ground will land. It will be
I'm asking for your professional opinion of that middle ground.
Yeah, so at this stage, the way we process an application like this is...
No, I'm not asking for I'm asking for your professional opinion. You're a professional expert here giving us independent advice.
Yes, so for an application like this, we don't see any, I don't see any justification for relaxation of our current rules. If there was some sort of geographical constraint, some sort of legal constraint, some sort of historic and unique design requirements that justified a relaxation of our rules, then we would consider it. If it was particularly difficult to achieve our current standards, I would consider it. But in this design, there is no reason for the current standards not being met. Therefore, I recommend the current standards be met.
So to follow up question on that, so should we go through each of those two issues specifically?
Excuse me, could I just ask, our traffic expert isn't here, is he?
He is here, and that's not actually for you to ask. Thank you. I'd like to go through the two issues specifically. We're in a position where we have an application in front of us with a proposal with specific layout, and we either grant or decline that. What I want to understand, two things, is I'd like to know your professional view on the two matters of that you disagree with Mr. Carr on, and then I would like to understand the process from here if we grant the consent, because what I'm concerned about is if we assess the evidence and if we prefer Mr. Carr's evidence over your evidence and we approve the layout as it is there then a risk that when you do your engineering approval, then this gets thrown out? Like what's the process? It seems a bit of a absurdity.
No, I don't believe so. My understanding of the way things work at our council is that we don't relitigate things like widths of roads later at 2 to 4 C states. That's all pre-agreed at the outset at this point.
When you say pre-agreed, do you mean our decision will be binding?
Yeah.
Yes?
Yeah.
Okay, thank you.
Yeah.
So therefore, I think it's really important for you to think about your role in the hearing. You're here as an expert witness, as a transport expert to assist us to make the right decision. So I think it's important for you not to use terms like we will not give an exemption, because it's our decision about whether we grant this or not. What we need from you is your expert advice about what the impact would be if we did grant the consent. So the two issues, if we can run through them one by one, the right of way at the top. Sorry, I might grab the bigger one.
Yes, that's right.
the right of way at the top here, in your report, or the original proposal, I think it was 6 lots that was going to service. The amended proposal is now 5 lots. What's your expert opinion about the functionality and impact of that right of way serving 5 lots, for those 5 lots?
Sure, so what we have. Used to that term.
Yeah, I understand.
The character of placing more lots on a right of way than the standard is something that I'm against. Partly because, as was mentioned earlier, the refuse collection is now a very important aspect of our infrastructure designs. And partly because the Three Waters engineering feed into our advice, find it difficult to service in the way they prefer. Three Waters underground infrastructure, the longer the right of ways become.
So in this case, have you assessed the amended proposal that's been put before? Huh? You had a look at that?
I haven't seen the 5 lot
Okay.
design, or at least I haven't seen exactly how that connects. I was looking at playing hand up for it, still looked like 6 to me. But I would just take a middle ground perspective that would be a compromise.
Yeah. So do you see any concerns from a traffic effects or I suppose servicing, because you're here as our servicing expert? No.
It's
Is there any major concerns from your point of view to have the 5 lots serviced via this right of way?
already difficult even with 4 lots on a 3 bin day. In layouts that provide specifically for bins to be counted in our district, we definitely do that now. We quite often have very specific pre-planned design details for bin positioning that can mitigate that concern. Then that's acceptable. When that hasn't been explicitly considered, then I would recommend you consider.
And this piece here, which is I think it's 15 metres, which the rest of the road is 20. Do you have any traffic related concerns about
I
the
do.
workability of that?
I know it's a unique road, but when I look at a diagram like this, I see a very easy chance for vehicle pedestrian interaction to a safety issue, which I dislike. The current channel is obviously
Sorry,
hard
can you
for me
explain that? Why do you see that? For what reason?
because they're close and there's no physical barrier.
Okay. It's,
Typically, there'd be a 3-dimensional barrier, a curved channel, or some sort of barrier. I think it's great having the pedestrian cycleway access. Having 20 metre reserve would make that amenity even safer. Having a physical barrier would make that even safer. So, as that stands, I would like to support it.
and the reasons for that is from a safety point of view or
Safety and character.
in character?
Some of the philosophical differences between our code of practice, the addendum versus 2010, and the reason that our council, and each council comes up with its own dimensions and layouts and preferences for the number of footpaths depending on the density of the areas, but character preferences district by district.
As in you prefer wider because it looks nicer. Yeah, okay. What would here you go.
In terms of your comments, Mr. Kirkman, then about character, is that within your expertise to be commenting on that technical area? How are you able to share a professional transportation traffic expertise in relation to character?
It's an interesting philosophical question. So my role is to apply the standard of our district, which includes aspects for safety and aspects for the character, which have been written by people who wanted to do that at the time. So I know the reason, the difference that I'm saying that I personally take a position on one or the other, but I know the reasons that those rules were put in, and so I support them.
Yes, and so you'd be looking specifically at your expertise in relation to those standards. So did you discuss the character side of things with the urban design when you reached that view? Whose professional advice, whose technical expertise are you relying on when you have landed on a reason?
For planning related issues, I talk to the planners to provide funding.
Okay, I think that's, yeah,
We'll come back to him on it.
yeah, we'll come back to you on the infrastructure matters. That's okay. Thanks very much for answering our questions. You read out a statement there. Could you provide a copy of that to Taryn, just so we've got a copy?
Yeah, sure.
Are you okay with that? Great, thank you.
Just on, in terms of procedure, when you
Yes,
the car prior, did you want us
I,
happy to,
can I just check? No, I think he's dismissing.
so in terms of our substantive reply, to the extent
Yes,
required, we could just address, and we'll have the benefit of Mr. Kirkman's written statement at that point, so we
Yes.
could address those matters.
that'd be very helpful.
Mr. Stobeck next.
Thank you.
I've got the rest of the summary as well.
Thank you.
That's right, it's never last very long.
Thank you. Yes, thank you. Kia
Sure, that's all right. I'm, land surveyor, looking for a long surveying firm in Zambia. And, yeah, been working for all the surveying for the last 4 years. I have a 1 years experience working, surveying in land Europe and New Zealand and other regions as well, so. My summary, or my evidence address the services and access components of the proposed division, focusing on the adequacy of network utility provisions and road and driveway formation. Overall, I support the majority of the findings in the section 22 report, but also the refinements to ensure the subdivision conditions are practical and appropriate, while remaining consistent with the current council standards and practice. My evidence address specifically right-of-way width and servicing, where I believe that a 6-meter wide corridor can adequately accommodate wastewater, stormwater, water, power, and fiber infrastructure for 5 lots, based on common main and actual layout. This approach is consistent with similar developments in the region and aligns with the current code of practice. Entrance lake width, which is the 15-meter wide corridor.
Can I just stop you there and ask a question as you go, just as we're going? So you're saying that aligns with the current code of practice? I think I might, I mean, obviously we can come back to it, but I think Mr. Kirkman said that that wasn't in line with the current code of practice.
I believe that maybe the current preference is not aligned with the current preference, but I can find in the current sort of practice where it could be not allowed.
Okay, thank you. Thank you.
The evidence also address entrance like width, where the proposed well and shared width are sufficient to accommodate the required services, and the road formation without land acquisition from adjacent properties. In terms of future connections, I support the inclusion of Sigmira shared utility corridor to the north to improve network resilience and interconnectivity, especially for water and possibly wastewater infrastructure. Servicing, roading, and irrigation requirements. Some of the conditions, in my opinion, seem too rigid and should allow more flexibility to be allowed for the engineering approval or acceptance stage. That includes conditions for water and wastewater servicing, which should accommodate alternative and efficient solutions. Roading standards, where different curb, channel, and surfacing options can be appropriate. And the irrigation bore requirements, which I think should be reconsidered to allow either bore or a reticulate water supply following a cost-benefit analysis. So in conclusion, I believe the subdivision layout can be appropriately serviced and accessed within the proposed layout. The recommended amendments should provide necessary design flexibility, align with the council practice, and ensure the development proceeds in a practical and efficient manner. That's the way.
Thank you, Mr. Sobek. In relation to the council recommendations around the bore or reticulated water supply, is there merit in having certainty in the conditions around the provision of water upfront, so that there is certainty on what is, yeah?
I agree. I see where you're coming from. I agree. However, this condition, so to speak, came out of the blue. And I don't think that there's been a consideration to, let's say, a benefit analysis. For example, we don't know what we actually are getting. How many trees, what area of grass, what is the actual water requirement for irrigation. And putting a bore for the future, I think it's a good idea, but servicing the bore comes with its own requirements and maintenance, so on. So in some cases, I can see that using actually a water reticulation can be more cost effective and beneficial for council in the future. So I think that this decision should be made after some sort of consideration at a later stage, let's say engineering approval stage.
So your evidence is that there's no risk that there isn't any water that there's not going to be a situation, perhaps, for example, where you've got this design, there's no water to actually do anything and to actually secure the outcome that has been.
I don't believe there's any risk.
There's no risk. Okay. Yes. And in terms of the conditions in your evidence in chief, you have provided some drafting options for us to consider. You've provided some drafting options for conditions for us.
Oh, yes, yeah, recommendations. Yeah.
And so is this, did you seek any drafting input from Mr. Barr when you put these forward, or is this are these your preferred wording changes?
I think these have been reviewed by Mr. Barr and been discussed, but this is what I would consider appropriate.
Thank you.
From
Thank you. Thank you.
I do have a question about a condition that you haven't addressed, which is in Mr. Barr's evidence condition 8. I don't know whether you have access to that. It basically says that an AccuFlow Tobian meter assembly must be installed on the street side of each street property boundary. Now, my understanding of that would preclude a common water main down the right of way.
That is correct.
So how would that, what is your evidence then in terms of that right of way and the provision of infrastructure?
Well, the actual, it would depend location of where the water will be. Phase would depend on the actual engineering approval. And the way to take, I guess that condition would be correct that we do preclude the location side of the road boundary within the right of way. No.
What did last?
What level must you? Yes, and that's hyperrealist, and that could also be probably improved to allow more flexibility in just stage.
So what's your evidence in regards to that condition? Would that condition work? Is the last sentence that I think Mr. Barr just pointed out to you?
Yes, that condition would not work if there was a common main from that other way, correct?
So what needs to be changed?
Would be rewarded. I would say must be installed on the street side of each street property boundary. Correct. Reading that again, if a property serviced by a right of way is not a street property boundary, doesn't have a street property boundary, then my understanding of this condition is that it must be on the street side of each street property boundary. But back sections do not have a street boundary, therefore this doesn't preclude for it will be to be in place within the right of way. Is that?
I don't know, I'm
Sorry.
asking you what this condition actually says. The way I read it, the Tobys all need to be on that turning head further down before the right of way. That's how I would read it, and you'd have to have 5 mains going up it. Or that exemption at the end, if it's not feasible, they could go, they must be cast iron to sustain traffic. But then the question is this going to be deemed not feasible? Which is what I believe the council evidence is.
Or locating the water.
Is there space for 5 mains to go up that right of way?
5 separate connections? Technically, yes.
Okay.
Yes.
So you could have 5 connections and the wastewater main, which can be communal.
Yep.
All in that space.
Correct.
Okay.
Because service connections, they can be separated by 100 meters spacing. So I would then we end up with maybe 600 meter wide corridor. 700 meters. I believe there's sufficient space to accommodate 5 separate connections
Okay.
and also for runway.
Would you be interested to hear of?
Not at this moment. No, I'd like to hear from Mr. Sobeck. Thank you.
Okay, jump in,
Yeah.
thank you.
Yeah.
Have you had a look at so I see in your evidence you've, as Commissioner Day Cleveland mentioned, you've made some suggestions to change of wording for some conditions. Thank you for that. Have you had a look at the conditions that were attached to Mr. Barr's evidence? He's nodding, but I want to know if you have. There are some differences in wording and things. What I might suggest to your council is that presumably in your reply, you'll come back with some amended conditions. I imagine that's where we're going to get to.
Yes.
What I would request is Mr. Sobeck specifically reviews those and if necessary provides us with an addendum statement about his satisfaction or otherwise from an infrastructure point of view.
Yeah.
Is that rather than put you on the spot now, because there's a bit of detail in that, I think it would be.
When at the time of writing the evidence, I have not reviewed the final
Yes,
conditions.
yes,
But
you have you now?
skimmed through
Yeah,
them
okay.
and we discussed that, but yeah.
Okay, well, I
The
think,
actual wording we have not.
yes, so what we would like you to do is, after today, we'll adjourn the hearing and what we'd like you to do is work with Mr. Barr and specifically review the conditions. And if necessary, provide us with a statement that confirms you're comfortable, or if you make any other recommendations to change those. Is that all right?
I
Thank
was
you.
just thinking that other technical and not on knowns as well, and I'm certainly more than happy for each witness to ensure that they've checked and confirmed if they're happy with the conditions.
Yes, thank you. That would be great. I'm good.
Yep.
Thank you. Thank you for your evidence and thank you for answering our questions.
Laurie next. Summary here as well.
Thank you.
Thank you. Thank you.
Thank you.
Okay, good, thank you
Kia ora.
for having me. So yes, my name is Rob Laurie, I'm a landscape architect, design, and I've been working with the Glenoir team for the last few years, providing landscape architectural design overlay. Very much a coordinated approach with this team to get to this point in time. And I'll take my full evidence and chief has read through my summary.
Okay.
So the proposed subdivision has been designed to respond sensitively and appropriately to the existing site context, topography and surrounding environment. The lot layout has been configured to integrate well within the large lot residential zoning, comprehensive residential development rule LLRZ 12, and to maintain an appropriate relationship with Dunstan Road. Smaller lots are positioned behind the existing larger lots at 157 Dunstan Road to ensure a gradual transition in scale, where larger lots are located on the lower slopes at the rear of the site. This arrangement, together with the setback from Dunstan Road and the potential for more urban density development anticipated under the large lot residential zoning, results in a well-integrated and contextually appropriate subdivision outlook. The development provides a variety of lot sizes to support a broader range of housing options, complemented by open space reserves and a well-considered streetscape design. The proposed streetscape accommodates vehicular and service movements while ensuring safe and legible circulation for pedestrians and cyclists. Generous berms are provided for the consolidated bin collection, car parking and street tree planting, contributing to an attractive, functional and open streetscape environment that enhances community amenity. Provision has been made within the scheme for future road, pedestrian and cycle connections to adjoining development areas, ensuring long-term integration and wider network connectivity. The subdivision layout strategically aligns the entry avenue, 15 metre wide section of the entry avenue and open space reserves alongside the high voltage open space corridor, which effectively utilises the site's primary constraint to maintain a sense of openness along the southeastern boundary. This also provides a suitable separation from the neighbouring property at 147 Dunstan Road. A single clearly defined entry avenue from Dunstan Road provides legible access into the subdivision and serves 3 lots within the 157 Dunstan Road parcel, therefore reducing the number of vehicle crossings onto Dunstan Road in accordance with CRDC objectives. And finally, the entry avenue incorporates a safe, accessible shared path linking the subdivision to Dunstan Road. Future crossing to be coordinated, of course, with CRDC will enable a safe connection with the Otago's rail trail and the wider pedestrian and cycle network, And the future crossing will also enhance active transport connections to nearby community parks and recreational facilities to the south of Dunstan Road. That is my summary.
I don't really have very many questions for you at all, no. The only note I've made is to ask you about the condition regarding reverse sensitivity and what you think of that. Which is not something that's in your evidence, but Mr. Barr has made us a suggestion for a condition about that. And I wondered what you thought of it.
I have.
It's condition number 27D of the subdivision.
Lots 15 to 19.
Yeah,
And as an occupiers, all allotments are aware of and will take reasonable and appropriate steps to advise on purchases, leases, licenses, and patents. The use of. So there's management concern with siting, design, screening of dwellings and other sensitive uses to mitigate adverse effects associated with noise and separation drift. Well, again, with these conditions, I haven't read them in full detail. This particular one, I've provided input into reserve and public space design sort of aspect to the conditions and elaborated more on what I expect in terms of I guess a coordinated, more detailed set of plans and specifications to develop that for the site in terms of a landscape layout perspective. And in terms of that particular aspect, I would need to.
you're welcome to say you just haven't considered it and you don't, that's fine. I'll just take it that you haven't.
Yeah.
Yeah. Is it all? I think so.
Yes, I had one question for you, on page 13 of the evidence in chief. At paragraph 36, you make a comment there that the properties at 165, 147 and 149 Dunstan Road
Yes.
will remain functioning as rural residential properties.
Yes.
You acknowledge that in time that might change, given they're also zoned LRZ. I'm interested in what has informed the statement that they will remain functioning as rural residential properties.
Well, at this point in time, and without crystal ball gazing into plans for those future sites, anticipate from my professional perspective that they will remain as current.
Yes.
And therefore, I've considered how those views, etc., into this development would be taken now and in the future, bearing in mind the potential they could be developed.
Sure. Okay. So it was more just that there's
Yes.
no signal at the moment.
That's
that
right.
Yeah. Okay.
Yeah.
Great. Thank you. That was my only point of clarification for you. Thank you. It's all very clear.
Right.
Thank you. I have no questions. Thank you for your evidence.
Excellent.
For relief.
Hello?
Sorry.
Sorry, thank you. Thank you.
Thank you.
Thank you, commissioners. I have a summary statement just handed around, take my primary evidence as read. I'll just start with the key points, I think. So I consider the context of the site, both spatially in relation to the growth of Alexandra and in the planning framework of Plan Change 19, supports residential development of the character and density reflected by the proposed subdivision. As we discussed today, the proposed subdivision design has been amended to provide for an additional pedestrian and cycle link leading to the north. I consider the nature and position of this lake, which is aligned with the location of the proposed local park reserve, as appropriate. It is my view that the provision of this lake is suitable in lieu of an additional road when considering future connectivity of the subdivision. I do not consider that an adjustment of the existing large lot residential zone setbacks from external boundaries is warranted, considering the future pattern of residential development anticipated by the zoning. I consider that subdivision design as proposed is supportable from an urban design perspective and aligns with the outcome sought for a comprehensive residential development. Finally, the proposal is aligned with the special plan and supported by the MPs. Any questions? Happy to answer.
Yeah, for me.
I have three questions for you. The first one is about the rubbish bins. Would you like to comment on the right of way to the north and the potential for rubbish bins?
Sure. So, in brief, my view would align with that of Mr. Carr's, that in this density, in this situation, it's essentially users will bring their bins out and will just get worked out. In cases I have been involved with in other districts, Queenstown specifically, there have been issues raised about number of bins, but that is in the scale of, say, 35 to 40 units. And here we're looking at, 5 or 6, maybe 7 individual properties bringing their bins out to the space, which I think can be accommodated.
Within that turning head?
Yes.
Okay. My next question to you is about, there's a condition recommending that 2 car parks per unit is a requirement. Now, I would think that was contrary to the MPS UD.
Yes.
What's your view on that?
I agree. It's contrary to, well, the MPS requires that there are no minimum parking standards. My understanding is that CRDC considers themselves a tier 3 authority that does not need to execute that division of the MPS.
So in terms of the last statement in your summary where you've said it's supported by the MPS UD, you still consider that?
No, my view is that the council falls under the ambit of the MPS. The reasons for that is that Alexandra, probably even Cromwell now, would classify as a housing and labour market, existing or planned for over 10,000 people. Particularly in the Alexandra context of Plan Change 19 and the medium density zoning, certainly there'd be more than 10,000 planned for that. So my view is that the council does fall under the MPS. I don't believe this application determines anything on this application. This application stands as it is under the district planning framework. However, my view is the MPS just provides support for it further.
Is it in your view appropriate that the council would impose a condition, or that we would impose a condition requiring car parking, or is that a private matter for the developer?
No, I don't think it's appropriate under the context of the MPS.
I don't have any further questions for you. Thank you.
I just had a couple in your in your summary. You referred to the spatial plan.
Yes.
That is that a broader Vincent's spatial plan that's sort of been incorporated by PC 19? Do you know how that process has worked?
I haven't been involved at any stage, just my reading of it, the preparation for this project. I believe that spatial plan is a process outside the district plan. However, its basis was used quite strongly to feed into Plan Change 19.
Yeah, the legal answer to that.
Yeah.
Hasn't been incorporated by reference into the district plan or into Plan Change 19.
Right, okay. But I suppose your comment is just that this is aligned with it.
Yes, if you look at it, section 1 for other matter.
Yeah.
It sits there and it's entirely aligned. Essentially because the current zoning under page 19 is reflective of the spatial plan.
And you'll note, I think you cover this in your evidence, that there's a recommendation by Ms. Batosi around a setback, 10 metre setback,
Yes.
particularly along the was that western boundary. Is that, can you see any situation where that might be appropriate given the large lot residential zoning that's on both sides?
No, so my position is that if we look at the zoning on also in the context of the site.
Yeah.
The residential patterning is being set by the zoning is in the setbacks and the building coverage and the height and all that has been established as being appropriate. My position is there's no need to adjust those for a bespoke response here when you look at what the ultimate urban outcome is intended to be.
Okay.
Thank you. It's been reflecting on the section 42A recommendation in reliance of Ms. Batosi's assessment. And there's a statement included in her evidence that says the site represents a transition between a residential zone and a rural zone. And I'm interested in exploring that with you. There's no transition zone as such that I've been able to see. From your urban design perspective and your reference points for your assessments, is a transition between a residential zone and a rural zone relevant?
So I understand that to mean that a large lot residential forms a transition, I suppose, between lower density, medium density in a rural environment. It's not always necessary, no, in urban design perspective. Then I question.
I guess I was just interested in exploring that some of the justification for the bespoke setback is that the urban design input into the section 42A report is that because the site represents a transition.
Okay.
And I'm interested in, is that how you see it? Do you? I
think I read that as more site specific, so saying it's more of a temporal thing.
Yes.
Because this, in fact, it is the first application in this area. It is the first of the rank, basically. So, that transition, I think, is talking about timeframes or progress in terms of urban growth.
Right. Okay.
So there was a suggestion that in response to that, there could be a setback applied, which is more rural in nature, I suppose. Whereas I'm saying this context is intended to be urban, large lot residential.
Yes.
That decision has been made as to what the setbacks appropriate are for that environment, and therefore this can be adopted without any.
Sure, thank you. And in relation, also in your evidence in chief, you look at the district plan provisions.
Yes.
In particular, you look at objective 2, and you've addressed that. Did you look at LLRZ Rule 12, which has matters of discretion, in particular D, which says measures proposed to ensure higher density areas do not detract from the character and amenity of the wider surrounding area. And so my interest is, if everything is set in the plan change 19 for this zone, then why would we have a specific assessment matter considering the wider area? So in terms of how this site interacts with that broader rural residential resource, for example.
Yeah.
Could you comment on that for me?
So my interpretation of that would be due to the flexibility enabled by the comprehensive residential development rule, there is some flexibility in terms of lot sizes, and consideration can be given to your edges, I suppose, and that's reflected in the design of the subdivision as we have here, where the larger lots are placed to the edge, while the smaller lots, which go down to 840 square metres, are concentrated in the middle.
Yes.
Yeah.
So if the anticipated density is what is reflected in the LLRZ, and they've got this specific matter of discretion to ensure that higher density areas do not detract, is that, so that's speaking from within so for example, within this proposal,
Yeah,
the higher density has been explained to us to be on the flat lower down. Is that what this assessment matter?
yes, I think so.
Right,
Because there is a small, well, actually reasonably large range of flexibility enabled. We need to look at the lot sizes
okay,
in that large lot residential zone.
thank you, that's very helpful.
Thank you very much. Appreciate your evidence. Thanks for answering our questions.
And then Mr. Barr.
Thank you. With summary.
Yes, so sorry.
Great, thank you.
No, just gonna be.
Your hand, thank you.
Morning, thank you. I have a short, just over 1 page summary. And I'll just speak to that quickly before I take any questions. Just at paragraph 3. By way of summary, the activity requires a restricted discretionary, sorry, I'm just referring to the planning framework here and the reasons for consent to summarize the map. The activity requires a restricted discretionary activity resource consent through the LLRZ framework. Overall, a non-complying resource consent is required because of the legacy rural residential rules which require a 2 hectare lot size. Paragraph 4, I consider the activities consistent with the LLRZ objectives and policies that are important. Policy LLRZ P9, which requires that LIM 4 that comprehensive residential development delivers of public benefit, such as public access reserves or infrastructure improvements. The proposed neighbourhood park, which will be landscaped and developed prior to the completion of the subdivision, is supported by council officers to achieve a public benefit and is supported to be vested to the council. In paragraph 5, just summarizing the status of the rural residential rules is that while they're technically applicable, they are not relevant and should not be given any weight. Paragraph 6, just covering that I address submission and evidence. And those submissions related to adverse effects on the amenity and outlook of adjoining properties, the density of the development, and that the activity did not offer any public benefits. The amendments made to the proposal prior to the circulation of the Section 42A report included several modifications which I consider have been effective at reducing adverse effects on those matters raised by submissions. These changes are that the density of the development complies with the large lot residential zone comprehensive residential development rules, and that there's a walking connection provided to the north of the site. And paragraph 8, overall, the application has been carefully designed and considered by the effective supporting technical inputs, which I consider has resulted in a considered and integrated approach to the subdivision and the development on the site.
Thank you. Is there anything else you wanted to cover?
Just briefly touching on the conditions and the conditions that are in my appendix 1 of my evidence. All the other experts or the applicants team had input into the conditions. If there's a discrepancy between what's in their evidence, it's probably my drafting might have tried to smooth out some of those recommendations to make the language either consistent with what was perhaps in the council officer's template or their style of drafting versus what I thought might have made better sense, which is not always the case.
Thank you. Firstly, just a couple of clarifications. At paragraph 50 in your evidence, you refer to 159B, and I wanted to check that you were in fact meaning 149B.
That's more than likely correct, Commissioner.
Thank you. Thank you. So in your evidence, you talk about the bespoke conditions. You refer to a suite of provisions that were included in the section 42A condition set. And you've said that you've marked them up or deleted them. And when I looked through the conditions, I couldn't see that they'd been deleted, but I think I then found them. Was it a placeholder condition which spoke to land use conditions, performance standard breaches placeholder, I think, or the section 42A breach. So there's nothing else that we needed to see
No,
struck out here, or?
no, perhaps I shouldn't have struck that out. It was placeholder text. I might have to delete it instead of striking.
No, it's showing. Yeah.
The only,
Oh, that's a different one.
Oh, sorry.
Yeah, there's
Which
another-
condition are we referring to?
It's at the end before, so
27.
It's one line.
So there's one at 27, there's consent notice, and there was a placeholder there, external boundary setback, landscape buffer. But I couldn't find anything else about you said there was a suite of provisions that you had deleted. And then when I went back to the section 42A recommended conditions, right at the end before the advice notes, there's a heading saying land use conditions, performance standard breaches, placeholder. And so I couldn't work out, is that what you had deleted, but you just inadvertently haven't shown it as deleted here? Or did those standards never actually end up in any condition set?
Yes, the latter, I think. I think
Right.
what happened is that in the AE as lodged,
Yeah.
there was a suite of
Yes,
conditions, and those conditions were proposed to avoid or mitigate effects based on the density of the development. And the council's reporting officer, council section 45 report raised, well, given that the density's been changed, there's been a reconfiguration. I'll leave these as a placeholder. And in my evidence, I said that these conditions are no longer necessary, with the exception of the building height condition.
Yeah.
So that's the process that led to that.
Mm.
So that probably could have been a bit clearer. And that the suite of provisions were the ones in the AE.
okay, right.
Yes, and the only one that has been followed through in terms of appendix 1 that you're looking at now is the building height.
Gotcha, that's okay, that clarified that. I wanted to check that I hadn't missed somehow a whole suite of
No.
deleted standards there, thank you. And at paragraph 31, you're talking here about the driveway in relation to property 165. And you've stated that the submission did not quantify the nature and scale of vehicle movements associated with any commercial activities. Is there any other detail you can share with us at this point around what that commercial activity is and any engagement you may have had with that property owner?
No, unfortunately not. Is all I know about that property is what's been identified in their submissions. So
Okay, thank you. I asked the question earlier around the phrasing of transition between rural and residential zones and the word buffer that has been used in the section 42A report. You've obviously contemplated this issue in your planning evidence. Could you talk me through in relation to the objective and policy framework of the LLRZ and how that is anticipated, in your view, to interact and relate to those properties surrounding which remain rural resource?
as a starting point, probably good to reiterate that the adjoining sites, the north, is I think it's very generally north and south, also zoned large lot residential. The sites obviously to the east on the other side of Dunstan Road are zoned medium density urban before you get to the Council Recreation Reserve, which is a golf course. So the only sites that are zoned rural are these sites to the, let's call it the east, as you said before, where there's that sort of the
So here,
spur of
here and
zone.
here?
That's right, and those sites are zoned rural residential.
Yes.
As a 2 hectare
Yes.
density. So when you look at the, and I think my initial comment would sort of echo what Ms. Costello said, and that the large lot, and this is helpful also, that while I'm explaining this, Mr. Laurie's diagrams are also quite helpful because they show, this context diagram shows the site within the context of the Vincent Spatial Plan. And so my understanding of the identification of this land to be zoned large lot residential and Vincent Spatial Plan, which was essentially implemented or given effect through Plan Change 19. The zone itself forms the transition between general suburban or lower medium density zones. And that's essentially the role and function of that large lot residential zone. So when you take that into context and then you apply the objective and policy framework, either which I have in the AEE, and I've got enough references so I clear my evidence, is that there is enough the references. Now I won't say this before I've got them in front of me, but if I can take you to okay, let's take you to paragraph 62 of my evidence on page 14.
Okay.
So when you're there, the policy LORZP9 Lim 1 says the overall layout provides for a variety of lot sizes and opportunities for diversity while still being designed to achieve the built form outcomes in large lot residential P1. My take on that is that the built form outcomes are the standards that are provided in the chapter, and I have provided an outline of permitted baseline or what the bulk and location standards are in my evidence as well.
Yeah.
LLRZ objective 2, which is there as well, also refers to changes to the environment. I'm paraphrasing this now because I'm trying to find it as I'm talking. Essentially, my understanding of it, interpretation of it, is that it's referring to changes to the environment based on the development anticipated by the zone. That's paraphrasing. I just didn't want to do the pain of trying to find it while I'm talking.
I've got the copy in front of me of the plan chapter.
Yes.
Yeah.
Thank you. So, in that context, when you're contemplating what changes are appropriate, and then especially with that paragraph 62 with policy 9, which is the key policy for comprehensive residential development, it essentially comes back to the bulk and location standards as anticipated by the zone framework to help inform that. A constraint or a determinative factor is that where you have a site that's less than 1,500 metres squared, that's authorised through a comprehensive residential development, that site, the building coverage is still 30%. So you're going to get a commensurately smaller built form. And so when you look at it through that lens, with the permitted baseline, which is a 1,500 net site area, will leave you with about 450 metres squared, 7.5 metre buildings, 3 metre setback. That to me, that's quite a strong guide as to what the outcomes would be, and sort of borrowing Ms. Costello's evidence here, where she's sort of said what you'd be looking at. You're trying to look at that and also look at the matter of discretion, which she raised in Rule 12. That's where you probably look at the overall development design and perhaps the selection of your high density sites. Depending on the sensitivity of the site or the density as well, let's just say, depending on the sensitivity of the site, for whatever reason, you might want to have some more bespoke setbacks. Let's say if you're adjacent to the edge of a lake or a water body, or an existing walkway, like an easement. And in this case, as Ms. Costello pointed out, the more sensitive part of the site is the elevated land that's adjacent to the rural residential zone.
Thank you, that's helpful to understand that. My other question was around, in your evidence, you comment on any kind of regional council jurisdiction for certain elements in relation to groundwater, stormwater discharge. And your view is that they don't need to be conditioned as part of the jurisdiction of this council. Is it handy to, in your view, to have any advice notes surrounding those issues in the absence of conditions?
Yeah, certainly. Yeah, it's a good idea.
Yes,
Feel we break?
yeah,
That's you.
yeah,
Great, thanks. I'd like to change topic to contamination. So I noticed that there was a DSI, and that recommended, comfort that the large majority of the contaminated material would be removed, but that any within under the road reserve could remain and be contained. I noticed that the council officers have recommended that the whole amount be removed. Obviously, I'll ask them about that. But have you had any experience with Phil, that, and I think it's arsenic is the elevated compound. Have you had any experience where that has been remained? I just noticed we don't have any experts here on that topic, but from a planning point of view.
Yes. Last week, most recently.
Helpful.
So scenario there was a farm landfill where you had posts and stuff put in the ground and it had been burnt, which I understand to have mobilised the arsenic into the sort of soil material and increased the risk of it being, swept away, even more unhealthily. So the scenario there was that the way that consent framework sort of rolled out was that there was an option to encapsulate the area, which means basically burying it in about 700 mils of clean fill and topsoil with a geotextile fabric between them, which is pretty simple. And that area is identified and put on consent notice as a advice note, really alerting the new landowners, the future landowners to it. The other option with that same consent process was that the consent holder remediated the material, which just meant taking it away and taking it away to an approved facility, having the land backfilled with clean fill and site validation report undertaken. So in that situation though, the point is that it didn't happen within a road. It happened, it was happening, it was a sort of similar-ish density subdivision. Actually, no, it was 1 hectare type density subdivision.
Yeah.
That was happening it happened within one of the lots, which there's plenty of room for everything else that happened. So without preempting your question, I've thought about this condition because just thinking about it today, without the benefit of having the applicant's environmental engineer here, just thinking about the council's reluctance to accept that the material will be encapsulated within a road and the ways listed to the council. The council perceived that as their problem to deal with. I think we need to go back and confirm this with the council's, the project team specialist, but to me, I don't see why you can have the option of that land being encapsulated within a right of way, or actually even within one of the lots. The lots are still about the lots that are well over 1,000 square metres. And with the 30% site coverage, you should be able to have sufficient area for that land to be encapsulated and then left alone, basically. We're not sort of dealing with a medium or low density development where the development's having some piece of that.
So would there be, you have to identify areas in a consent notice or something?
Yes, that's what usually happens, is that the location where, the location where it's encapsulated is identified, is geospatially identified, and it's attached as a condition to the consent notice. That would be.
It's probably in the application somewhere, but is there a map somewhere that shows where it is, and is it still near?
Yes, it's a certain area and it's a relatively small area. I think to boil it down, it's where someone might have, with one area with hydrocarbons, that's where I think someone was doing oil changes and.
Oh, I see.
Well, and there's, things like that.
Who's got that?
Three or small sites.
Has someone got a plan they can show me?
Is it page
Yeah.
157 of the agenda maybe? Is it this one?
Yes,
And is it this small
Looks like it.
squared area here? It's
Yeah.
not in colour. It's that area there.
I believe it's a reference to an estimate of 10 cubic meters.
So, Mr. Farr, what you're suggesting is that that land is, so I hadn't understood this from the DSI, but was the suggestion in any event to dig it out and then put it in the road? So instead you're saying you could dig it out and put it somewhere else?
you could, because that's what encapsulation is.
I understand that's what, my understanding was it was already in the road and it wasn't being moved a long way, but when I see it just here, I'm seeing it's being moved a few hundred meters
Yeah.
anyway.
That might be the case.
So that's the intention, right? Okay.
Yeah.
And your conditions that you've recommended, condition 1 of land use,
So what that does.
Yeah.
Deletes the recommending officer's version that says that.
Yeah,
That
right,
happen
hold on.
expect,
yeah,
must not be encapsulated in the road reserve. So at that point, my recommendation was to include within the road reserve while confined to the following, and that provides limb A. Provides the off-site disposal. And it also says on-site encapsulation to be confirmed from identification of the quantity and nature of material.
yeah,
On-site encapsulation of the road reserve, and then it provides some parameters that may, or that I consider based on the advice from that specialist to potentially appease the council's concerns that it won't be located near surfaces.
So are you now recommending that condition is changed?
Yes, I just what I'm saying is as an alternative. I don't see why the material can't be stored either on a lot or within a right of way. Providing there's
that's encapsulation.
sufficient you should call it an ongoing site management plan, but the only really ongoing site management, just to know that's there.
So if it's 10 cubic meters in total, why would you not just remove it?
That's an option as well.
I mean, can I ask you, is there any reason why you wouldn't just
So,
accept that?
We would most certainly remove 10 cubic meters. It just takes care of a small issue.
Yes,
That optionality is again in this vein of let's not predetermine things at a consent condition stage that we don't need to, with the input of the environmental engineer and the review and acceptance of a site management plan as part of the engineering approval process. Let's figure out among those details what the right treatment is and not sort of preempt it at a consent condition stage. That's what that optionality was seeking to achieve.
but I mean, you've done the DSI, you understand where the contamination is, you've got your layout. What is there more to know to help you make that decision?
Well, in the same vein as, let's say, an accidental discovery protocol, you don't know whether you're going to find a clay pot or a
Yeah, that's a
human
different
remains,
matter. Not
and therefore, in digging up the site, should there be other material found, then presumably what we want as a developer and what council wants as regulator is a mechanism that says we've got a way of appropriately addressing what we encounter without having to run into problems of constraining consent conditions.
So what I understand you're saying is that it's your intention to remove the, say, 10 cubes that you're aware of,
Absolutely.
but if further contamination was found, you may not,
Figure out how.
you may not want to remove that.
I suspect you would need to be back for further consent if you found further contamination. And for 10 cubic meters, when you're moving it across the site, it doesn't really add up to then say, we want to be able to encapsulate it. By the time you've dug it up and stuck it in a truck to move it across the site. Okay,
Well, if you could deal with that in your reply, that'd be helpful. Just perhaps give that a bit more thought.
Thank you.
Okay, thank you. In terms of the conditions more generally, Mr. Carr was talking about, and also Mr. Sobek, oh, not so much Mr. Sobek, but Mr. Carr was sort of saying there are some matters around detail that could be left for the engineering approval phase. In your experience, is the level of detail that's being proposed in terms of the subdivision conditions in particular, is that more detailed or more onerous than you would normally see in a subdivision consent? Or
It's about,
I think it's things like the curve and channel issue and
yeah,
those sort of things.
it's a little bit more, but having said that, where the council officers have come from is because something specific is proposed. So I think that's where
Yeah.
more details come in, but I've said, well, we're not sure about that. So here's some conditions to make sure that, because the understanding is that condition one says in accordance, unless otherwise sort of explicitly stated or sometimes overridden by another condition.
Mm.
So there's a little bit more detail in there, but that's the kind of result of the specificity or the indication that was sort of desired by the applicant.
Yeah.
With regard to condition 16 with A, I mean, that's quite fundamental around,
Right.
it's just that example where it is a specific condition, but it's a fundamental issue with the electricity constraint.
So an example would be 16F,
Mhm.
where you've deleted the standard curve and channel. By deleting that, does anything need to come in to replace that in terms of how that design will play out through the design and engineering approval process?
Potentially, it's probably something that I could defer to Mr. Sobek and Carl just to make sure I'm not making a sweeping statement. I
Yeah,
mean, the condition underneath deals with swales,
Yeah.
but they might think, well, no, that's not quite the issue here. We're dealing with the curve and channel.
Yeah.
So I think
it'll be worth,
yeah,
thank
take
you.
your advice on.
Well, I'm not giving you advice, but if you could review that condition
Yeah.
in terms of certainty. Because I would have thought that you would prefer certainty in your consent conditions so that when you get to the engineering approval phase, you're not having debates with the council about detail if there's something specific. Is that fair?
To a degree. So where we come unstuck is where we haven't done design work. We don't know what an optimal outcome is. There are options that need to be worked through. There's no point in constraining. So to avoid variations to consent in order to get an engineering approval, we would prefer a distinction between a set of flexible guidance, keeping us within the sort of the appropriate consent time, acknowledging that there's a bunch of detailed design input of experts, possibly some inevitably some liaison with council about what a best outcome is. We have no issue with safety. We have no issue with keeping pedestrians and cyclists away from vehicles. We simply haven't designed a solution. And similarly, this issue of a bore could be the right answer. We just don't know.
That's fine. Yeah, that's great. Thank you. So Mr. Barr, in terms of the road width, the 15 versus 20, from a planning point of view, so what we've been told is that there's an existing approved subdivision at 155 Dunstan Road. And so my understanding, am I correct, that to be you can't, you just, there's not enough room to do 20-metre road coming up the side. That would essentially mean, so what does that mean from a planning point of view, that in hindsight, the applicant should have allowed more space to come up the side, or what? I mean, I'm just interested in.
No, it's probably a little bit more. It's accommodating with that. I think that from a planning perspective, especially when you're hearing two experts,
Yes.
one saying 20 metres is preferred. As the code of practice says, so, and it's really important for the integrity of how the consent authority, undertakes its business and its subdivision development. And then you got an expert saying, well, 15 metres is fine, and it happens in lots of other places.
Can you speak up a bit, Mr.
Sorry, although, did you catch what I said?
I caught it, but just.
Yeah. From a planning perspective, I think the council, not Central Otago Council specifically, but a council would need to be cognizant that you're dealing with infill development, even though it's a sort of freshly minted large lot residential zone, essentially infill of 2 hectare rural residential, which has created the subdivision pattern at the moment. And I'm not a development engineering officer, but in those sorts of developments, I understand that you tend to get a 10-metre wide legal width right of way to service some of those backlots for that nature and scale of development. It might have a form to leave the clarity of what it needs to be. So I think with a council, I don't want to say this as a criticism to this council, but when the council is contemplating infill development, it probably needs to think about how it can be reasonably accommodating, that it's not dealing with a greenfield development where you've got all the options in the world. So I think that's something that should be taken into consideration, both at this conceptual stage and also at the engineering approval stage, that there's going to be constraints that are the legacy of the previous zone. And sometimes it might mean ultimately that the yield that's provided on, let's say, paper for subdivision development of a site might not be able to be realised because the access is constrained. And even though you might be able to have, let's say hypothetically 15 lots subdivision, but the code of practice says, after X number, which is less than that, you need to have a 20-metre wide level width and formed as road invested. That's a constraint. Well, that's something that's left for the resource consent process, and I think it needs to be probably clarified at the resource consent approval stage, not left for another first principles debate through the engineering approval. You need to understand what the effects are, what the implications are at that initial resource consent stage. And coming back to this site, in the context that it has, for whatever reason, the access of that isn't, the access isn't, doesn't achieve 20 metres, and that's a sort of configuration, it's a legacy of the site. But at the same time, there's supporting technical evidence that 15 metres can accommodate that development. And I think that's probably the important landing point for me.
Okay, thank you. Yeah, sure.
I've got a few questions on conditions that I might go through with you, Mr. Barr. Your condition 6A that you've added, which is the staging condition, refers to the proposed road in the reserve being completed first, and says the proposed road lot 30 needs to be completed first. Do you mean lot 31?
Yes, I do.
Okay.
I've got a couple as well.
Condition 22, as raised by Mr. Carr. I would agree with Mr. Carr that that is not a condition of consent that's suitable on a resource consent. It's not within the applicant's ability to control the speed limit on a road. Would you agree?
Yes, and I thought it's said as much in a passing comment in my evidence, or maybe I didn't. but
Okay,
I-
I didn't see it, but
So just to be clear, because you've kept it in there.
Mm.
What's your expert opinion on the fire raise of a condition like that? Because I know that the applicant is able to offer conditions, but if they have no control about how they can give effect to that condition, is that a concern?
That's just to reiterate the council, this is the Black Texas Council's.
I understand.
Yeah, your context as well is that we're not, I guess would be inherently volunteering as well by not opposing it.
Yeah,
Yes, that's correct. I mean, some processes we know require a road to be vested or reserved to be vested, but in this case, because it's often undertaken under the eroding bylaw, and it's subject to a whole lot of other parameters, I wouldn't support that condition in this instance. It's too subjective.
do you,
Uncertain, sorry, is my word.
thank you. Do you want to make any comment on the vesting issue? And how that might work in this council? Maybe you have a lot of experience working with this council.
A little bit, but I've never worked for this council previously. People to my right are probably best placed to explain that process, but
Okay, that's fine.
yeah.
I don't need to. I'm interested in the 6 metre building restriction. So all of your experts and yourself have said you don't support any restrictions which are beyond the zoning provisions, but yet you're proposing a 6 metre height restriction. I'm wondering why.
That's probably something I could have explained better in evidence where it was sort of set out in the AEE, and then the application being amended. I probably could have spent a bit more time on that. The 6 metre height limit compared to the 7.5 metre height limit that's stands in the zone provisions. The 6 metre limit would limit, buildings to essentially single story, perhaps with a loft. That, from my planning perspective, is quite a strong determinant of what the outcome would be of built form. And given that we are in a comprehensive residential scenario, I think that building height limit is still appropriate to be retained. What it would do is it will provide, it would avoid a sense of overdevelopment, of visual dominance, potential privacy and overlooking, where the density of the subdivisions, I suppose, marginally higher than the minimum lot size requirement of 1,500 metres squared, where the sort of gross area is being taken. So I think that's why that condition's supported by me.
can I just take you back up, condition 25? You've referred to, and B, you've referred to consent holders should provide detailed landscape plans and documentations. Do you think there's a need in there to either refer to a draft plan that's already been provided, or at the very least state what that plan is trying to achieve? Because you've talked about certification by council. My reading of that, it's very open. It does say the documentation shall achieve, but to me, that's really more about the information that needs to be provided. I wonder if it would help the certification process.
Yeah.
If it had a more of the objective is to or
Yeah.
just to link that back.
Yeah, I agree.
Okay. And there was in terms of the setbacks, I understand that you don't consider the 10-metre recommended setback to be necessary. Am I correct that the applicant is seeking to reduce? There was a reduction in setback being sought in the application. Do we need to have a condition that states that, just to be very clear?
There's no reduction sought anymore, so
That's
default,
completely gone.
that's right, we default to the 3 metre zone provision.
Okay.
Sorry, for internal setbacks, it'd be
Yes.
3 metres, yeah.
Okay, so there's no land use consent sought to reduce setback requirements at all through the
Not
whole
anymore,
proposal. Okay, thank you. Just about a minute.
Just the question on the car parking spaces and the relation to the MPSUD. Asked Ms Costello. My understanding is the MPSUD got rid of car parking requirements, and for the council to have a condition like this seems somewhat contrary. What's your planning view on that?
Can you stay me to the condition?
It is 27B.
Yes, no added within garage spaces. There's no harm in it. The allotment sizes.
I realise that it's very likely that people will provide 2 car parking spaces anyway on this allotment size. I can understand this. My question is whether or not this condition is appropriate for a council to be putting on, given the MPSUD provisions.
Well, for context, Central Otago District Council don't consider themselves a tier 3 local authority. My understanding of that is informed through Plan Change 19. And I don't know of any changes in policy, either at a consenting authority context or from a planning authority context. And I mean, there is the council and its role right during this district plan.
One of the evidence pieces of evidence did refer to it, didn't they?
Yeah, I think.
Oh, right.
You rely on
And
the
Stella.
Yeah, I do. And it's a qualification that the Vincent Ward, even if you look at the Vincent Ward and the Cromwell Ward separately, is that they meet the definition of its environment in the NPSUD. That's probably, I think, where we're at with this proposal. You don't need to hear me providing my philosophical views on that, but
No.
on that basis, and because of the size of the lots, and the nature of the development, I don't see any reason to oppose the condition. And at least from the consent authority's perspective, they probably feel like they have the ability to impose that condition.
Okay. Thank you.
Council just informed me too, he's just pointed out that the MPSUD talks about a constraint on rules, not necessarily conditions of a resource.
Yeah,
So,
yeah.
yeah.
That's that's probably the answer I expected from you.
He got there.
Got there in the end.
Well, no, I was just interested really on the whole
Anything
thing.
else?
I don't have anything else. No, thank you.
That's all we have for you. Thank you very much. As I said, it would be good for you to
Yes.
relook at some of those conditions and obviously coordinate in with Banner and come back to us in your reply. Look, I'm mindful it's 12:30. It's actually getting a bit, I don't know if you guys are getting, when we're getting sun on our backs, getting a bit hot in here. I am happy to take the lunch now and we'll have half an hour and we'll come back at 1. But if I appreciate you have been sitting here all morning very patiently. Mr. Davis, would you prefer, sorry, that's you. Yes, would you prefer to come now or are you happy to take a half-hour break and what's your
I ain't
preference?
got much anyway.
Okay,
My submission.
no, don't need you to tell me what it is. I just need to know whether we're going to adjourn for lunch or not. So you're happy to come now? Okay. Yep, you come on up, come and sit at the table. Thank you. Yeah, perfect. You just it's been since you couldn't want me to. Now we'll just pull up your submission and get ourselves organised and then we'll talk with you. Good. Really? Great. Thank you. Can I just confirm your submission, you part of 2 submissions? Yes, so you had submission 12 and which was yourself and Shirley Davis, and then you were part of the submission 10, which was a group. that right?
Yeah.
Are you speaking on behalf of the border group today, or are you speaking on behalf of you and Shirley?
Just me.
Just you. Thank you very much. Thank you. In your hands, what would you like to tell us?
Well, we were concerned about our water bore being infected,
Yes.
especially now they're talking about the arsenic not being taken off completely off site. They've got the wastewater is just going to go into our drain down and end up in our bores. And I think it's like originally I thought the deal was that the arsenic was meant to be taken completely off site. If it's going to be shifted over to a roadway, then you're contaminating that truck, the digger that's moving it, the ground that's moving across. They said originally they're going to take it away, and I think it should be.
Okay.
My other one was to do with the, you've read in it and you've been out there and seen the gentle slope to the north.
Mm-hmm.
You realise it's no gentle slope. I got boo-hooed by their experts, because to me, like I'm next door. There's been a lot of earthworks done at my place and compacted in, but my place is different. I've got a massive big area that can be shifted around. These sections, to me, the rear of 20 and down the side of it on my side, it's all going to be terraced all the way down. You just can't, there's not enough area to bulldoze that sand out and then not impose onto the next one down to it. And I got in their submission, and they have replied, they said that basically it was nothing to do with you guys, that it was a regional council to decide on that. But my argument is they have brought these rear sections purely because of the size of them, so they can get away with making the ones out front smaller. But I don't think that they are able to be built on. And like I've just built a big shed on my place. I've had to put a retaining wall behind it. I've had to shift sand off on my own property. There's no way that, like, say if you sold 20 and then 21, say, and then want and set that up as a section, how's 20 going to get on up there? Like, it is extremely steep about that section, and for them to say that it's slight incline is just rubbish. And you would have seen that as being out there. I also feel.
Sorry, can I just stop you so I can fully understand what you're saying? Are you saying the quality of the soils is the ground is so bad that it's unable to be built on without substantial?
Floating foundation and that, yes, you can build on it, but the problem is the section's not being very big. How do you terrace it down to each one?
I understand you, yeah.
And the same issue with the road that they're going to put up there, that right of way. I don't know how they're going to build it in sand. And that's going to be as steep as well.
Okay.
But I'm no expert, as like, because the experts told me that.
Well, your information is very helpful to us.
I have built on it and I know what it's like, and that it's just sand, there's no bottom to it. As far as them changing their application, why didn't we as submitters get a chance to reply to their changes?
So that's your opportunity now to do that. So the amended application was filed and that's was publicly available. So have you had so this is the updated plan. I think you've got that in front of you.
Yeah.
Have you had a chance to look at that at any stage?
Oh, yeah.
Yeah. Can you let us know does that change your views about because one of the matters you raised in your submission was the section size, and presumably you sort of talking about the density of the property. Does your view change at all with this amended layout?
Well, it's got better in the fact that they've gone back to some sections, but originally they said 22. But
So just so I'm clear, it's a positive for you that the number of lots will be reduced with that amended.
I'd like to go back to where it was spoken to in the first place, 22, and abide by the council rules.
So the 22 was that something they discussed with you initially, or?
That was on their first plan, and that's, as far as discussions go, there's been none with any of the neighbours. They haven't talked to any of us. There's some of them that had phone calls. I had one visit right at the very start. I've never heard from them since. Karen will know that Hughes have withdrawn their APA. They signed an APA on the original submission, and then that got changed. They haven't been part of the mailing group. They hadn't been approached at all about the driveway across the property being shifted. The only reason they know is because I told them, and I had to forward on all these documents. So they have signed and sent it to Taryn that there's nothing going across their property. They've got no permission to do anything.
So is that 149 Dunstan Road you're talking about?
Yes.
This property up. Sorry, it's a bit small.
Yeah, the one down below me. The one-
Yes, below you. Yes.
Yeah.
Yeah. Okay. Thank you.
Because the first I knew about it was to be a roadway put through the middle of their section out onto our driveway, which seemingly because they signed an APA to start with, then they had no choice in the matter. But now it's been shifted down to the other end of their section. They knew nothing about it until a couple of weeks ago when I told them, and they have had phone calls from Garden, but they have signed nothing, so there's no new APA. There's no permission for them to do that.
Well, just to be clear, we're considering the application on the applicant's land.
Yeah.
So we're not if we did grant it, we wouldn't be providing any approvals to anything onto a neighbouring property.
Right. So the fact that an APA has been withdrawn, does that not get mentioned to everyone in here?
That's something that if they've done that, that will be relevant to our consideration.
So you've got that email to you.
Right. Okay.
I've seen the email. Right.
We'll follow up on that. Thank you.
Right. That was my lot.
No, that's great. Thank you. I'll just see if there's any other questions while we've got you. Very helpful to have some locals. Has anyone got any questions?
No, that was all very clear. And yes,
Any questions?
we visited the site. It's always useful for us to understand the issues that you bring.
Yeah.
So we've got in our minds exactly what your concerns are, and we've seen the elevation and the levels, and we'll consider the information you've provided very carefully. Thank you.
And just we'll have to own up and let you know that we did sneak in up and drive up your driveway. We did knock on the door, but I don't think you were home. So apologies, we'd normally give advance notice about that.
It gives you a bit.
We really wanted to have a look from your property, so thank you in retrospect for that.
You see how much earthwork was involved in ours.
Mm.
If we only had a little narrow section like that, 20 or 21, you can't do it.
Can I ask, were you involved in the plan change 19 process? Were you involved in that at all?
No, because it didn't basically affect my place because I'm above and under.
Thank you very much. Really appreciate you answering our questions.
Right, thank you.
Where else we'll keep going?
Yeah.
Mr. Meldrum, you wanted to have a quick chat. We'll just pull up your submission. So if you could get yourself settled, we won't be a moment.
So mission 9.
9, and then can I clarify? So you prepared a submission yourself and Alison,
Right.
and you also prepared a submission on behalf of a group.
Yes.
Yes.
But that was with group input.
Yes. And are you here today representing that group, or are you here just representing yourself and Alison?
Well, both have two submissions, and so I'm going to make reference to both of those.
Okay, and you have authority from all of the people that were named on that submission?
It's been intimated that I would be here. I intimated them that I'd be here and they were comfortable.
Okay, that's helpful. Thank you. Great. Excellent. What would you like us to be aware of?
Well, I won't reiterate the detail of those two submissions. As you've already said, I have my name on two submissions, one individual and a group submission with 5 others. Both those submissions oppose the application. As I say, I won't reiterate that, but I would make a couple of very brief comments. Firstly, with regard to the personal submission,
In considering the application lodged under comprehensive residential development rules, the hearing panel will be cognizant of the objectives of the large lot residential zone, which is clearly articulated in the plan change 19 as a pleasant, low density living environment. At the same time, while the panel has specific matters of discretion to guide its deliberations, it will be aware that its decision may well be a precedent for future large lot residential zone development in Alexandra. With regard to the group submission, I reiterate concerns voiced in that submission, namely that comprehensive residential development rules should not be invoked solely and simply to legitimise higher density development.
It's your statement. It's very succinct. Thank you very much. Got any questions, Mildred?
Mr. Meldon, which site do you live on?
165 Dunstan Road.
Yes, 165, okay. Yes,
Yeah.
I was just interested in the comments about, I just wondered whether you had any comments to make on the quality of soils around there.
Soils.
In terms of building.
The soils are sandy with fairly shallow gravel base. I can only speak for my property, it may be different.
Yeah, I realise that you're not up the hills much, okay.
Forest.
Have you seen, can I ask you, have you seen the latest subdivision plan that was circulated
No.
this morning?
Up until now.
You've seen it today?
I've seen it today.
Great. Have you had a chance this morning to have a look at that while you've been sitting very patiently?
Well, the only thing I'm really concerned about here is the potential road which is going to be into access onto 165 potentially. This has not been part of any discussion that I've had at any stage, and it is relevant. If you look at my individual submission,
Yes.
you'll see that I have concerns around that sort of thing.
Yeah. Okay. Thank you. So, and that's this right of way that you're talking about here that the applicant's now proposing, at the request of council, to be fair to them, to provide a future option to have a cycle or pedestrian access if the site at any stage was ever to be developed. I'm assuming at this stage you're not intending to develop your site. Is that part of your plan at the moment?
Not today, no.
Not today, fair enough. And so do you don't have a preference either way, presumably then, if that's there or not, because obviously it's.
No, but I would go back to my submission where what is done on this development will affect future development at 165 potentially. The outlook for starters will be directly influenced by a development of this nature, of any nature next door.
Yeah. Okay. And the size of the lots, or the number of lots has been reduced slightly with this updated plan. Is that something that you'd see as a positive, or
well,
don't have a view on?
My comments a few minutes ago, I would suggest that I find that not particularly positive.
So you think there should be more lots on the site?
Well, I think if we worked under the, if we weren't working under a comprehensive development plan, that would not be the case. It wouldn't be a problem. I have no problem at all with the rezoning.
Right. Okay, I just want to understand that a little bit more. So you're happy with the rezoning, the large lot residential zone?
Yes.
And the evidence we have is that the density proposed is in line with that zoning. So
I'm aware of the expert evidence.
yeah, so do you disagree with that evidence?
Yes,
or?
I think the comprehensive development is an inappropriate mechanism on that side, because I don't think it quite, I also in the group submission have referenced that, suggesting that the site itself is not appropriate. for comprehensive residential development for resident gate.
Okay, so you don't think the site is appropriate, but the zoning for the site is appropriate?
The
Well,
zoning,
we
the
don't,
zoning of the site is fine.
right, the large lot residential,
Yes,
yes.
comprehensive residential development on that site is inappropriate. I itemised that in the group submission.
Yeah, I'm interested in what you would see as an alternative then. What would be an appropriate development under the large lot residential zone on this site?
Well, sections which were larger and came much more within the realm of the objectives of that zoning, which, as I said, is large spacious residences. It's property, sorry, subdivision sections.
So larger sections?
Yeah.
You're
Yeah.
larger than what's proposed?
Yeah.
Okay, thank you.
I think the exercise is largely an attempt to fit a size 11 foot into a size 10 shoe. Perhaps that's frivolous, but it's a simile that works.
Mr. Meldrum, in your submission, you raised concerns around a rural service type activity that you undertake on your property. Is that correct?
I mentioned that I run a business on the property.
Right. Okay, so are you able to just share some details about your concern in relation to that business, the nature of your business and what concerns you had?
Well, the business is run from the easternmost edge of the property. I have industrial freezer there. I have transportation from time to time up that drive to that facility. Essentially, it's a berry processing facility. We grow on a remote property and do some processing and some repacking at that facility.
Okay, thank you. And what is your specific concern about what is proposed in relation to your operations?
The road that's proposed.
I was asking you what your concern is. In terms of what's proposed, what is your specific concern?
Well, obviously, that driveway, which is 200 plus metres long, bounders very close to a number of homes.
Yeah.
That has implications. It has implications as to what sort of boundary demarcation occurs on that property.
And you're talking about this boundary along here?
Correct.
Yeah, and is this where you have your freezers and things?
Yes.
Yeah, okay, great.
Okay.
Thank you.
So are you concerned that your activities may be constrained by the introduction of these houses along that boundary? Is that
I'm concerned for safety.
Safety.
If there are 7 or 8 properties along that boundary, particularly if they are young families, and if there is some sort of porous boundary, then there is potential
Okay,
for some adverse events.
okay.
So would you support some fencing or something of that nature?
Well, I think it's a discussion that has to be had in detail. I mean, I'm not aware that a specific type of fencing has been asked for. It's a discussion I'm willing to have and have already had initially with the applicant.
Okay, thank you. That's very helpful.
Thank you, Mr. Meldrum.
Wanting us to consider fencing, say no what you want.
So just before you go, we'll just pop back down. In terms of the your concern about safety, I mentioned that you might be interested in agreeing some fencing with the neighbour along that property to sort of prevent young children or people running out onto your driveway. As part of this consent, if it's something that you think would mitigate the effects on your property, it's something that we can consider is to impose a condition requiring the applicant to fence that boundary. We wouldn't specify the type of fence, and obviously that'd be discussed with you, but is that something that would help to alleviate your concerns about the proposal?
If it was articulated, it probably would, yes.
Okay, thank you. That's very helpful. Thanks very much. Right. Okay, thanks everybody. We will now adjourn, and for lunch we'll be back at 1:30. At that stage, we'll have questions for the 3 council officers. And then we'll discuss replies and things from at that point. So we'll re-adjourn at 1:30. Okay, we'll reconvene. Thank you. Ms. Copeland, we've got you first on our list.
Yeah, would you mind?
Do you want
We swap the order?
to? Yeah, no, that's probably a good idea.
Yeah, thank you.
Okay, so Mr. Kirkman, I think we're back to you. In terms, particularly in relation to infrastructure. We'll just see if we had any questions specifically. We might have actually covered most of it.
I just have 2 questions for you. One is, I've understood your concerns with the right of way at the northern end, but I just want to understand a very specific matter, which is there space for infrastructure, being potentially 5 separate water main connections and 1 communal wastewater connection in that right of way?
So my understanding is that, yes, technically there is, but the 3 waters department engineers prefer not to have to
Okay.
put that much.
Yeah. And do you know what the code of practice says about communal wastewater mains? Is that an acceptable solution?
3 water department at our council is departing from the code of practice and transitioning to the National Engineering Design Standards, the NEDS. So they don't take the code of practice as the reference for their designs.
Right. Okay.
It does complicate things. That's part of the reason our 2010 base standard hasn't yet been released.
So does the NEDS allow for a communal wastewater? You can say, I don't know if you don't know.
Yeah, I have seen the diagram. I'm not an expert. I believe there are options for that, yes. But
Okay.
whether that's something they choose in this instance, I couldn't say.
Okay. My other question to you is about the issues raised by Mr. Davies in relation to potential geotech on sites. 22, well, those sites up there, probably anything between 17 and 22. There's no geotech report with this application. Did you think one was required in order to be able to ascertain whether whether the applicant will, or whether people will be able to build on that in the future?
No, I think the evidence of the nearby neighbours building proves that it can be done. It's just very difficult. If it was a narrower section, then that would be more difficult, but anything can be done. It's just going to cost more if the grounds are less favourable.
So you're comfortable that this subdivision could be consented without a geotech report, without posing the risk of allotments being created that are undevelopable?
That's right.
Right, thank you. I have no further questions.
I have a question in relation to I think it was Mr. Carr suggested that there would be benefit in having a kind of coordinated crossing over Dunstan Road to enable cycle and pedestrians to access the rail trail. Is that something have you had any conversations, or are you aware of any sort of proposal around that?
I know that the applicants are keen on providing a safe and useful community asset to access the cycle trail.
Yeah,
Conversation we had, I recall, was just that, so we.
you would be as well. Yeah. Do you think it's appropriate to have a condition in the consent about that, or is that something that you would deal with separately?
Given the nature of this subdivision, that wouldn't be necessary as a consent condition.
Okay. Yeah. You got anything else? Yeah, great, thank you. Right, Ms. Batosi, are you able to hear us okay?
Yes, I am. Hello.
Hello, welcome. Have you been listening today? Have you
I
been
have.
sitting in?
Yes,
Brilliant.
I've been listening all morning.
Okay, is there anything you wanted to address us on first before we ask questions of you?
I just wanted to comment on the 10-metre setback that I had proposed. I agree with the applicant's planner and urban designer that the proposal presents a density that is anticipated within the zone, and that this is the first development in a wider area on the eastern side of Dunstan Road that is planned to transition from rural to residential in character. And I also note that the sites on either side to the north and the south also share that same zoning. It could be many years before some of those neighbouring sites develop, and so I think the setback would assist with integration with the character and amenity, both within the existing and the planned character. And the other point was for the part of the site at the eastern end where the large lot zone projects into the rural zone, and also bearing in mind that steep topography. In my opinion, that is quite a sensitive interface, and that 10-metre setback would assist with integration.
Thank you.
Is it proposed?
Ms Batossi, is that you referring to lots 20 through 22?
Well, really 16 through to 22, yes.
Thank you. And are you familiar with the Plan Change 19 policies and objectives?
Yes.
And so do you think there's a policy framework that supports that sort of the integration with their neighbouring rural residential land, even though it's zoned for large lot residential?
I was looking at
that.
I was looking at the matters of discretion.
Okay, just a moment. So that's, just to be clear, that's, I think it's R12, is it?
R12, yes, R12.
Yeah, okay, thank you. Yes.
Measures proposed to ensure high density areas do not detract from the character and amenity of the wider surrounding area.
Yeah, okay. And when you read higher density, what do you understand that to mean? Is that higher comparative to other parts of the site, or higher compared to other areas adjacent to the site?
I've read that to mean higher than the current character. Of course, there are much higher density zoned areas around, but within this context, higher than the current character.
It's Commissioner Day Cleveland now. Just on that note, when you say higher than the current character, explain that for me?
So the current character has, I think the rural residential zone has 1 house per 4 hectares, and this is obviously higher than the current character, but noting that it is anticipated within the zone.
Yes, and so with the LLRZ zoning, it's been established that even with appeal, it's unlikely to return to the character that you've described of the current.
Right. Yeah.
So
yeah.
Is that a relevant reference point for your assessment?
I think it is, and I think that the flat area for that reason is less sensitive than the eastern end, where the surrounding zoning is still zoned as rural residential zone.
So to be clear, is it your assessment that it is necessary in terms of mitigation of adverse effects to have a 10-metre setback from lots 16 to 22? So we'll deal with that first.
Yes.
Because of the adjoining rural zone. Yeah. And then in terms of lots along the sort of the western boundary between the site and 165 Dunstan Road. Do you think it's necessary to require a 10-metre setback along that boundary in terms of mitigating the effects of the proposal?
I think it would assist with integration within the character and also help to mitigate the effects of the proposal on that neighbouring property.
Okay, thank you. That question.
I just have one question for you, Ms. Patossi, about 149 Dunstan Road. In your evidence, you've said that it's understood the applicant intends to provide an updated written approval. Now, we haven't seen an updated written approval. Would you be able to give us a brief assessment of 149 Dunstan Road?
I haven't seen an updated written approval either. I do note that the smaller lots of the development are located along that boundary. So there is the potential for more houses to be closer to that boundary with the 840 square metre lots, but I haven't seen any update about the written approval.
So what would your advice be to us if we don't have a written approval?
Then I would suggest that 10-metre setback would apply there as well.
In paragraph 5.26 of your evidence, Chief. Just let me know when you're there.
Yeah, just finding it. 5.26. Yes.
You have a comment in here around while the proposed density aligning with the expectations of the CRD, the configuration likely results in one or two additional units that would be located closer to the boundary than what could be anticipated under a conventional subdivision pattern, typically associated or typically anticipated with the large lot residential zone. And my question is there any what prescription in the planning framework are you relying on there in that that in your view a typical subdivision pattern is required in this zone?
Did I say is required? What I was meaning there is where I've got those lots, for example, those lots 23 to 27, which are 840 square metres, a more typical subdivision of 1,500 square metre sites would mean that instead of 1, 2, 3, 4, 5 houses along that boundary, there might only be 3, for example.
Yeah, and I guess my question is then what in the policy framework requires only 3 lots across that boundary? Like what is the policy that's driving your reference to having a conventional subdivision pattern on this site?
That was an assumption of 1,500 square metre sites.
Okay. Thank you. At paragraph 5.32.
Yes.
You're referring here to 149A Dunstan Road. I'd like to just confirm that you're actually referring to 149B here.
Yes, that's right. That's a typo there. 149B.
Thank you. Answer the questions.
Nice running. In your, so I'm just sort of, I don't want to labour the point, but in terms of the setback requirements, and you've referred to the matters of discretion, and this might be a planning question, but they are informed by a policy framework for that particular zone. Did you have a look at the policies, relevant policies? I'm just checking your evidence.
Yes, I did. Yeah.
So are there particular policies that you're relying on around the sort of, from what I'm taking from what you're saying is some sort of a protection of a an open space kind of character, given that the property immediately adjoining hasn't been developed yet under the Plan Change 19 provisions. Is there a policy direction that tells us that's the way we need to interpret this new zoning?
One of the objectives, 3, is provides a good quality of on-site amenity and maintains the anticipated amenity values of adjacent sites.
So it talks about existing or anticipated development in these areas. Is it your read of that means we need to protect the existing and not look ahead of what the new zone would provide for?
I think we do need to look for what the new zone would provide for, but we also could integrate with that existing character.
And is it your opinion that a 10-metre setback requirement is necessary to achieve that?
I think particularly at the eastern end, yes. At the flat area, possibly not so much.
We'll just check if we've got any more questions. Yeah, no, I think that's everything. That's all we have for you. Thank you for your evidence and thanks for answering our questions.
Thank you.
Ms. Copeland.
Thank you. So I'm going to summarise some of my overall findings of my Section 42A report and move on to points which have been raised in evidence and at the hearing as they relate to my report.
Thank you. Have you got something written that you're going to read to us?
Yeah.
Would you be able to provide that? That's brilliant. Thank you very much.
I'll start it up first.
Yeah, that's fine.
So just scattered throughout this, I might talk to some of the draft conditions.
That would be very helpful.
Yeah. So firstly, one amendment to the Section 42A report is required in relation to the calculation of financial and development contributors. The figures included in the Section 42A report were based on superseded investment, which was done when the proposal resulted in 30 residential allotments. A revised assessed contribution has been done based on the 28 allotments, which does reduce the overall contribution down to 517,000 roughly. And I'll make sure that that full demand notice is circulated. So just to summarise, I concluded that the proposed subdivision and comprehensive residential development will maintain the character and amenity values of the broader area and adjacent properties. I had concluded that the proposal was inconsistent but not contrary to objectives 16.3 from 10 and policy 16.4.1 and 16.4.7 as they related to a coordinated and ultimate pattern of development, adequate access and servicing. And I otherwise concluded that the proposal was consistent with the objectives and policies of the district plan, Plan Change 19 and any other higher order documents. I recommended that be approved, subject to a suite of conditions. I note the applicant's revised aspects, they do not change my overall recommendation. So let's talk to some points that were raised. The first one is about the irrigation board. This condition does have recent precedent. This was an arrangement that was proposed by Molyneux Lifestyle Village, just further down Dunstan Road, which has recently been approved. Another subdivision of Mutton Town Road, which I was involved in a couple of months ago, that had the same condition imposed. And also I understand Prospector Park, which is the Cromwell Holiday Park extension. The advice that's come out is also proposes the same condition. So the I guess the basis to that is that given the national direction, it's looking like there's going to be a lot of increases in water charges, specifically around domestic water. And I think council's concern is the use of domestic water that would possibly cost a lot to irrigate trees and parks and berms is possibly much of a financial onus on the council and on the ratepayer. So the idea behind it is to use non-potable water for irrigation in those areas by sinking bores.
Can I just ask while we're on that topic, the other examples, were they, do you know if the applicant offered that condition or agreed to them, or is that an imposition that council?
I believe in the Molyneux Lifestyle Village one, they had a bore. So they proposed to use that. Same situation with Prospector Park, Mutton Town Road, they agreed to it.
Okay, yeah. Thank you. Oh, and sorry, last, so do you have, does council have any understanding of how viable a bore is on the site to be able to supply this sufficient water?
Yeah, I believe there is bores all the way along Dunstan Road. That I don't believe there's any constraints to.
In terms of supply, okay, thank you. Thank you.
So just reiterating Mr. Kirkman's statements about our current code of practice, which have been traversed a little bit. I do note that the district plan, the district plan kind of does state that we have a code of practice, but that local deviations can be supported. So a breach of the standards, the engineering standards, does not trigger a law breach in the district plan. So that is inbuilt into our district plan, that there is that element of flexibility, but it's designed to kind of give developers some guidance on the expected standards. Yeah, so Mr. Carr's evidence confirms that the applicant is willing to volunteer a condition of consent about pedestrian and cycle crossing on the Dunstan Road. I agree this would represent a good outcome in terms of safety and connectivity for passive travel movements. I think that could either be sorted out at engineering approval or possibly built into condition 16B. I think either way would be acceptable.
Sorry, can I just pull up 16E? Oh, yeah. Thank you.
So in his evidence, Mr. Carr reiterates his position that the proposed 15-metre legal width for the central line road is appropriate. I stand by my comments in section 42A report where I ultimately agreed that the legal width does not directly impact on safety and efficiency of traffic movements. And just remembering that the district plan does direct that it might be appropriate for deviations where there may be some constraints. I do accept there is a constraint here in terms of the width of the legal buses that we're dealing with. I suppose the mechanism to change that would be via a boundary adjustment subdivision, which is a controlling activity under the district plan. But I do note the complications where the subdivision on 157 is has progressed through to the titling process, and that will involve third parties by the sales that are signed sales and purchase agreements. So I do recognise that.
Sorry, I thought, just wanted to clarify what you said there. So I thought you said at the beginning of that section that you had accepted that the 20 metres wasn't necessary.
Yeah, and I'm just saying I recognise that there's constraints.
Yes.
Yeah.
Okay, and then in the conditions, in your version of the conditions, you did have a 20 metre, so your views changed.
Yeah,
and you're comfortable with the 15, as Mr. Barr's got it in 16A.
Yeah.
Okay, brilliant, thank you.
So Mr. Carr raises the issue of curb and channel formation. I continue to agree with Mr. Kirkman that some form of physical barrier, particularly on that entrance, would be preferable, just to increase safety. Just noting that a couple of seconds of distraction, for a motorist, which kind of result in conflict with pedestrians. And whether that be curb and channel or some kind of other fence or bollard systems, I continue to support that. And that would necessitate maybe just a slight tweak again to condition 17, 16.
Yeah, is there, and I think Mr. Barr agreed with us that perhaps if condition 16F was to go, then 16G needed a bit of work, and maybe that's something you could work with him on.
Yeah, I agree with that.
Okay.
So I note the revised proposal which reduces the number of allotments accessing from that eastern right of way that we've been talking about. So in general, so in Mr. Sovik's evidence, he talks about drains in common. I think if commissioners were of the mind to impose that or allow that to go ahead, I'd prefer that some time was taken to defer to our council's Three Waters team to just check that it was practical and feasible. Just bearing in mind that you're locating public assets, private land. But agree it could be worked into that condition to allow possibly that approval process to come through.
So which condition are we talking about? Have you got a reference?
So it kind of feeds into the other.
Yeah.
I did note condition 12 here. Well, so firstly, it feeds into condition 9, which I note Mr. Barr's already provided an amendment, so we could potentially have shared water main going up there. In condition 12, Mr. Barr hasn't proposed an amendment to that I can see, but that would need to be amended if a drain in common wasn't proposed. Right? And that a similar amendment could be added as otherwise approved by council's Three Waters department.
Yeah. And while we're on that topic, the proposal has reduced the number of lots for that right away from 6 to 5. Given your assessment of the evidence that you've heard today, is there do you see that do you have a view on whether that's appropriate or not?
Yeah, it sounds like the evidence from a transport perspective that no one's really raised any issues with that. And in terms of servicing, I think there's possibly a way through.
Yes.
By maybe just altering the arrangement there. So I think reducing it down to 5 is a small but quite a meaningful amendment.
Thank you.
So I'll just go on through the issue of connectivity.
Yeah.
Specifically the road connection to the north. That was recommended by Mr. Kirkman and Mr. Tossi. So in my section 42A report, I concluded that the proposal appropriately provided opportunities for connectivity, that initial road connection would enhance that. There seems to be 2 key objectives that I picked up that related to connectivity. One's in the large lot residential zone, effective 2. Which describes the character and amenity values of this zone as being well designed and well connected. But then there is no reference to connectivity in any of the associated policies, of the large lot residential zone. And in a quite similar vein, the subdivision chapter of the district plan contains objective 16.3.10, which requires an appropriate and coordinated ultimate pattern of development. And again, there's no corresponding policy that relates to connectivity. In reviewing these two objectives, maybe rightly or wrongly, I considered objective 16.3.10 to have almost stronger wording when it talked about the ultimate pattern of development. And that was kind of what led me to conclude that the proposal was inconsistent with that policy. Just because I didn't think it met the threshold of an ultimate pattern of development, which I consider to mean, a pattern across multiple sites.
Is that though partly because the other sites haven't been developed yet?
Potentially.
I mean, it's a wee bit, you can't expect everything from one landowner, can we?
Yeah. Which is probably why I didn't consider it to be contrary.
Thank
To
you.
that. But I know the applicant since proposed a pedestrian cycle connection to the north. I reckon that is that will positively impact on general connectivity. And on balance, I now consider that the proposal is consistent with 16. Just going on to another point that was raised was on the national policy statement for urban development. My understanding is that Central Otago District Council has not confirmed that we are a tier 1, 2, or 3. I believe that is to do with the fact that to meet those growth and population thresholds, we have to draw from outside of the strict urban area to do that. So as a planning department, we generally don't consider that policy statement. Contamination, again, my recommendation that it was taken to a licensed facility is based on internal advice. The council doesn't seek to proactively inherit contaminated land. As the ratepayer bears the ongoing responsibility of the contamination. I understand the total quantity is about 10 metres cubed, which I'm not sure, but I think probably fits in one truckload. So I don't consider it to result in an unreasonable financial or practical burden on the applicant to remove this to a licensed facility. So in that respect, I don't support Mr. Barr's proposed amendments to condition 1 of the land use consent.
When you say internal advice, who does that come? Is that
Does that come from the roading department and property department, and our parks manager as well?
yeah? It's a bit tricky for us.
Yeah.
Do you have record or memos?
Potentially.
Or is it a conversation, or what was
Yeah,
the?
probably a conversation. It does probably traverse across a number of applications as well.
Okay, it's a general approach. Okay.
Stance,
Yeah, that's fair. Okay, no, that's fine.
Condition 27, as it relates to reverse sensitivity. Fundamentally don't support the changes recommended by Mr. Barr. I maintain that this reverse sensitivity consent notice should be retained and should apply to all allotments. And that's just recognising that there are existing uses in the immediate receiving environment that have been legitimately established, and that does include permitted rural activities. That does have the potential to conflict with residential activity. Probably more in that intervening period, while adjoining sites are
Mm.
developed.
And it may be that those sites are never developed.
Yes.
I mean,
Yeah.
yeah. And how does that work in practice? Do you know? How do those, so it's essentially an advice requirement. Is it part of a consent notice? Yeah, so it's put on the title, and then if someone's buying the property, they are aware of that.
Yeah, it's just kind of making people aware.
Yeah.
As a council, we do receive a lot of complaints about first sensitivity.
Okay.
And so it's just one mechanism that could potentially reduce some of those complaints.
So are you thinking it's required for all lots?
Well, that was my, yeah, that was my assessment.
Okay.
You know, there was,
They're almost, I mean, they're sort of the central ones, but it's sort of,
you know, these peaks can traverse across.
and on that condition, 27D. Yeah. So I understand your recommendation around the first bit that Mr. Barr's put in, which is lots 16 to 19, and you just wouldn't have that.
Yeah.
What about the other changes that he's recommended to Romans 2 and 3? Did you look at those?
Yeah, I had a look. Point two, I don't really understand why some of those are crossed out. Because I think those things do happen in these areas. I live in an area very similar to this, and we do all those activities.
Okay.
And so, yeah, the expectation would be that those activities do occur.
So essentially you're saying retain that part of the condition as per your recommendation.
Yeah, would agree with the changes to the third point though.
Oh, 3 is fine.
Yeah.
Okay.
I think the last thing is that I agree with the removal of the speed limit mission.
Oh, okay.
Yeah,
Okay, thank you.
and that's all I had.
Excellent, thank you.
Can I just ask you about that consent notice condition? I've just pulled up section 221 of the RMA, which says where a subdivision consent is granted, subject to a condition to be complied with on a continuing basis by the subdividing owner and subsequent owners, a consent notice can be imposed. Is this a condition? This is just telling someone something. Is it really appropriate to put this on the title as a consent notice? There's nothing to this. What does this condition actually require of anybody?
Well, it doesn't require, it's just addressing reverse sensitivity. Not specifically the effects of such, I suppose. It's generally conditioned that most applicants will volunteer the post in this district. But yeah, you're right. It's just kind of an awareness condition. It doesn't fundamentally seek to manage any effects as such.
I wonder whether it even meets the standards to be a consent notice.
Potentially.
Has the applicant volunteered it in this case?
I would need to check that. I can't remember.
I would say, assuming, considering they've crossed some bits out, they possibly have volunteered an amended version.
Yeah.
Okay.
One thing I wanted to just check with you, I think I'm right, it's later than, well, it's not even late in the day, but we've had a bit on today. You haven't addressed specifically the setback issue, have you?
Oh, no, I haven't.
No, and that's fine. I appreciate that, we talked to the other experts about that, but I guess what I'm interested in from a policy position, I mean, obviously we've got 2 experts, one saying from an effects point of view, we don't need it. Another one saying, well, it would be nice to have it, particularly on that top piece in terms of integration. So I understand from an effects point of view, but from a policy position, what do you have any views about? I mean, this zone it is a zone, large lot residential. You could just put a house there quite close to the boundary.
Yeah. Yes, I would agree with that. suppose the conclusions of my section 42A report was that, the proposal without that setback was consistent, with the
Yeah.
policies. I consider there to be enough policy strength, to find it inconsistent or contrary, which is why I suppose the sentiment throughout my report is that it possibly a nice to have, but not fatal to the application.
Okay, that's helpful. Can you get into it?
Can I just ask you about the vesting process? What do you know about that? Can you talk me through how it would work here?
Yeah, in the break, I sought some advice on that. From what I understand, councils will stick to the determinations in a subdivision consent around that. So if an agreement is made of a certain construction formation of a vested asset, we would stick by that through the process of previously investing.
Okay.
I asked about the other situation that was raised and
From more
didn't have a
campground.
recollection of it
Yeah.
occurring quite like that.
Yeah.
There is the potential that when we go to someone goes to 224C and we inspect the asset and if it's not up to formation, we will require them to upgrade it. But generally, what's in the consent is the standard that we stick to.
Okay, that's really helpful. Anything else?
I don't know if I have any other questions.
There's one point I want to check that I've understood or that we've got covered off today. There is some contestation around, as I understand, for the future buildings on lots 23 to 27. There was some dispute around whether it should be 4.5 versus 7.
Yeah.
Have you addressed that?
I haven't.
So is that setback?
Yes, boundary setbacks. Yeah, so that's lots 23 to 27.
Yeah, the background to that is I understand that there's been an incorrect setback applied in the Clean Change 19 rules
Yes.
that we're seeking to change because the decision doesn't reflect the decision
Right.
of the commissioners.
The provisions.
Yeah.
The
Yeah,
the
provision.
decision version of provisions.
Yeah.
Doesn't reflect the commissioner decision.
Yeah.
So are we talking about LLRZ S6, setback from internal, oh no,
Setback from a road boundary, I believe.
okay, that's S5. S5. So that's not,
Yeah, they 7 meters. The decision of the commissioners was 4.5.
oh, I see.
And so where does that leave us in terms of what is,
Yeah.
what can, if we're of the mind to, grant consent? Legally, what's the legal situation there? I guess that might be interesting in reply, but.
Yeah.
Has it played out before?
I just missed that last point. What was the?
There's a kind of an academic dispute, if you like, between standard LLRZ S5, which the decision version of provisions has at 7
Oh,
metres.
yes, I got that. Yeah.
However, Ms Copeland has just advised that the actual decision that commissioners
Yes,
made
yeah.
was 4.5. So now we're just uncertain where that should land in terms of our consideration of that standard.
Well, I think in terms of assessing the rule itself, it has to be what's in the provisions.
Mhm.
But if it's clear that from a more contextual perspective that was intended not to be the case, then that can be taken into account in terms of how consent might be.
Implemented, yeah. Is there any documentation that sets out that we could have look at just to understand that context a bit more? Thank you.
And is that something that council's looking to correct? Because you could your advice that you
It is
can
still
do that
subject
without
to-
the process.
Sorry,
Oh,
it's still subject to appeals. It's
Ah,
not, it's
okay.
standard.
Yeah.
Oh, just in part, maybe.
you can actually just correct that under the course of the same planning process.
My understanding is the applicant's no longer seeking a land use consent to breach that at this stage. We're not considering that, are we? So it's an immaterial matter for us.
Right, okay,
Yeah.
so that's covered off.
So this, yeah,
Thank you.
so that 7 metre would apply. Anything else from you?
I think with,
Yeah.
Finishing speak question.
Yep, thank you.
So just for context, if the panel were of a mind to impose 10 metre setback, then the 4.5 metre or 7 metre road boundary setback becomes more critical. So just for context, this annotated plan here, if there's a 10 metre setback imposed along these internal boundaries of the site, then sort of by implication that reduces the area where building can be located as a permitted activity. So currently, when the application was first lodged, there was a condition proposed of a smaller lot that they had a 4.5 metre setback. That's when there were 4 lots along that right of way. Now there's 3. So that condition is no longer sought because of the extra size of those lots, and people can build to comply with the 7 metre rule. The rule actually only affects lot 4, which has road frontage. So, and currently the way you've sort of canvassed this enough, but as an appendix to the AEE, there is some documentation on that rule, which is what Ms. Copeland has said, that the hearings panel's recommending report agreed with the council of the section 42 report. In that process, that 4.5 metres was appropriate for the setback. But the change isn't reflected in the decision version provisions, which were transposed into the district plan that we agreed today when we looked at it online.
Yeah.
So to the extent that it matters to this process, it sort of has a bearing on what might happen on here as a condition. And I could be wrong, of course, money flights here, but I think Ms. Vitossi projected relaxing the road boundary setback as a consequence of the condition. I'm not sure, we might need to check with that. So I hope that's helped.
No, that's
Thanks for
useful.
taking time.
No, thank you.
Good to hear, but I need to make a call on the rules this today.
Well, good on that, aren't we?
Well,
Well, I don't know. Just the 4.5.
can I, sorry, can I just, my understanding is you took that out as the amendment, as part of your amendment, and that would require a separate land use decision from us. So it's quite critical that you've taken that out, and as far as I'm concerned, you've taken it out, and you could now be putting it back in, but we need to be very clear whether you are.
No, they don't need.
You're not.
Anyway.
Okay, great.
I can deal with them there. So disagree. Yeah. Okay. Is there any more questions? No, you got anything else?
No, thank you.
Thank you very much for your work, and I really appreciate you addressing those issues on the fly. If you could get that document through to Taryn, and would you be comfortable working with Mr. Barr just on some conditions? And we'll talk about timing shortly. Great, thank you. Great, so that's everybody heard. Am I right? No one's sitting there feeling missed out. Great, very good. In terms of your reply, I assume you'd like to give that in writing?
Yes, and I was going to say, given Ms. Copeland's comments and your point to her just then in terms of liaising with Mr. Barr, it could be an option that happy to do it all in one go. But if there's going to be a collaboration between the applicant and council on condition, whether that might be an initial step. Both council and its position on what the conditions end up with as part of its reply, or in your hands as to the.
So, yeah, I mean, the two options I see are either the planners deal with conditions and pull in experts as necessary, and that just comes back to us, and then you do a reply after that responding to that.
That was mine.
We have two steps, or, which would be more efficient for your client, well, quicker in terms of getting his decision out, if you just do that in one step. So, I mean, we're happy to receive it either way, but basically what we need is an updated set of conditions, and it needs to be clear whether the council agrees with what they agree and what they don't agree with, and that the experts have reviewed and are comfortable, and whether your client's whether they're not comfortable with any of them. And we also obviously need your reply on those matters. And I'm happy to have that in one document at one time if you'd like. But I mean, it's up to you really.
No, I think in one would be fine.
Okay.
And I think, I was thinking rather than having a reply responding to points in the hearing followed by conditions. I think.
Oh, yeah, no. Yeah, definitely. Yeah. Okay, great. So have you had to think about how long you need to do that?
Well, in terms of responding to the points from the hearing, I don't think probably more than 10 working days. But if in terms of the liaising with council, I'm happy to extend that or shorten it if that's ample.
Yes. So that would, if we took it to the 7th of November, that's a Friday. I'm just mindful we've got Labor Day.
Yes, I'm told Ms. Copeland you're away in a couple of weeks as well.
Yes. Well, let's get it done before you go. So 7th of November, is that workable for you and your team? Yep, that's workable. So we'll expect a reply and a set of updated conditions with response all in one package.
Yeah.
By the 7th. If that's going to be problematic, obviously you can issue a memo and ask for an extension. And then from there, we will make a decision whether we need any further information to make our decision. If not, we'll formally close the hearing. We don't reconvene to do that. We just do it, and then we will issue our decision. So at this stage, we are not anticipating asking for any further information, depending, of course, what comes through in your next pieces of documentation.
Thank you.
Is there anything else? No, great. All right. Thank you, everybody. Thanks so much for all your contribution. It's really useful for us to hear from a range of views. So thank you for taking the time, particularly the neighbours. We really appreciate you taking the time to come today. That was really helpful. Thanks to the applicant team, very professional presentations, and thanks to the council team as well for all your work. Thanks to Karen, as usual, for your wonderful running of the hearing. We couldn't do it without you. So I will adjourn the hearing, and we'll expect reply and conditions on the 7th of November.
Thank you.
Thank you.